here that it is rebooting itself here.
Yeah. Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, September 7th, 2022. I apologize, we're getting off a little bit late. It's 9:34 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith. I'm John Neerman. For those who are joining us virtually, please remember to mute your microphone when you're not speaking. For those who are making presentations, please wait to begin your presentation until either I or our General Counsel have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we'll do our best to accommodate that request. We have a very full agenda today, to say the least. I appreciate everybody for being present. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Port Arthur LNG LLC for air quality permit numbers 158420, PSD-TX 1572, and GHG PSD-TX 198. The order of presentation today will be applicant, followed by protestant, the ED, and then OPIC. The parties were notified that they would each have 5 minutes for argument. The applicant may save time for rebuttal as it bears the burden of proof on the applications. And so we'd first call the applicant.
Good morning, Mr. McDonald. And just let's confirm that the green light is on your mic.
There we go.
All right, whenever you're ready.
Good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janecka. My name is Derek McDonald with the law firm of Baker Botts. I'd like to reserve 1 minute for rebuttal, please. It's my privilege this morning to be here to represent the applicant, Port Arthur LNG, which is seeking new air permits for the expansion of an LNG export facility on the Sabine-Neches Ship Channel. With me today is Jim Thompson, the Permitting and Compliance Manager for Port Arthur LNG. The record in this case overwhelmingly demonstrates and supports the Commission's approval of the application and issuance of the permits. The judge has fully evaluated the issues that you referred to SOA for a hearing, and the proposed order before you recommends issuance. This recommendation is based first and foremost on the undisputed finding that emissions from the facility will be fully protective of human health, physical property, and the environment for all citizens of Texas, including those who live farther away, over 5 miles in Port Arthur, the city of Port Arthur, a city that also supports this particular project. Only the BACT issue was litigated in this hearing, And on that issue, the judges found that the permits reflect BACT limits except for NOx and CO from the refrigeration compression turbines and NOx from the thermal oxidizers, which they recommended have a slight reduction. We accepted to those recommendations with respect to the turbines only, as did the executive director. And in our exceptions, we highlight why the evidence in the record showed the judges erred. The definition of BACT requires that an emission limit be achievable, which in turn requires the limit to have been demonstrated in practice by a similar source. But there is no similar source that is achieving levels of 5 ppm NOx from turbines at a similar source. This recommendation was based primarily on a permit that was issued to an LNG facility that has not yet commenced construction. The record shows that SCR for the control of NOx is not cost effective, and even the judges agree that SCR is not required to be used, leaving the best performing similar source as the one that's Port Arthur LNG's sister source in Louisiana, which was permitted at 15 ppm NOx but achieved regularly 9 ppm in practice. With the lower emitting turbines now available, we propose 9 ppm as BACT here for Port Arthur and expect that they also will better perform and overperform that limit. With respect to the CO limit, the judges found that Pecan failed to rebut the prima facie demonstration on the CO BACT issue. This should have been the end of the analysis. Pecan did not rebut their demonstration, did not meet their burden in the Senate Bill 709 case, yet the judges went on to conclude that we should again match the 15 ppm limit for CO proposed, again, but not yet demonstrated by a similar facility. Like with NOx, we believe that our newer turbines can meet this limit. And in our briefing, we actually deferred to the commission to make a determination whether the order and permits in this case should reflect the more stringent limits that we believe are beyond BACT that are recommended by the judges. Finally, we want to note that this hearing should not have been held because Pecan's member, Mr. Beard, is not an affected person. By a split vote, the commission referred the affected issue to SOA for hearing, and SOA took considerable evidence on that issue and granted party status over the objection of us and the executive director. SOA's finding was premised on a theory that has never been accepted by the commission before, one that equates any modeled increased concentration of an air contaminant at a location with increased risk of health effects. We believe that such a standard, that any modeled increase, no matter the distance from the regulated facility, confers standing, disregards established law and commission precedent. We urge the judges to provide that analysis to you during the hearing by way of certified question. They declined and rejected that invitation. And even today here, as you consider this proposal decision, it has simply no analysis of the affected person issue that was referred to, that you referred to them for consideration. So we accepted to the proposed order on that reason too, and believe that it's important for the commission to reject that theory and provide an independent basis for the issuance of these permits. Thank you.
Thank you, Mr. McDonald. Colleagues, any questions for Mr. McDonald? Okay, thank you.
So I believe we'll call up the protestants, and I think we have 3 people signed in to speak for them.
Good morning.
Good morning, Commissioners. Thank you for allowing me to speak a few words today. My name is Chase Porter. I'm from Lone Star Legal Aid. I'm counsel for the Protestant Port Arthur Community Action Network. I'm joined virtually by my colleague Amy Den and co-counsel from the Environmental Integrity Project, Colin Cox. They're both available to help answer any questions you may have today. A year ago, Commissioner Neerman, you stated, and I quote, "This authorization is not trivial due to the character and quantity of the emissions proposed. We are grateful that this authorization received the attention it warrants. The ALJ's findings in their decision represent no less than 4 days of hearings and the lengthy written and oral testimony of no less than 12 witnesses. Pecan presented nationally respected experts whose reputations and work span from coast to coast. Their close review of the facts in this case and their testimony helped develop a very thorough record supporting both Pecan's standing, John Beard's affected person status, and deficiencies in the proposed permit. The proposal reflects a hard, detailed, and careful analysis of Port Arthur LNG's choices of pollution controls and the consequences of those choices on the people of Port Arthur. Your adoption of the proposal for decision today would significantly lower emissions of nitrogen oxides and carbon monoxide into the surrounding communities by requiring lower emission limits for the facility's refrigeration compression turbines and thermal oxidizers. I will note, as Mr. McDonald just said, even the applicant itself does not object or accept to the lower emission limits for its thermal oxidizers. I do want to highlight now a letter which the EPA sent to TCEQ last week. I hope you've all had a chance to take a look at it.
I'm going to stop you here for a moment because that letter is not in the record. It can't be discussed in today's arguments. Thank you.
Okay. Well, I will pivot real quick. As we discussed in the record, and as Mr. McDonald just stated, they rely heavily on the idea that if a technology is not operational and demonstrated in practice at other LNG facilities, that it cannot be considered backed. As we developed in our briefing during the case, we believe that the EPA's guidance and the TCEQ's guidance simply does not support this suggestion. If it is commercially available and applicable to the facility, it must be considered a possibility for backed. Ultimately, the proposal for decision reflects TCEQ's stated mission to protect our state's public health and natural resources, consistent with sustainable economic development. While Pecan did not win on every issue, Pecan believes that the decision brings Port Arthur LNG in line with other facilities in Texas and is reasonable in balancing public health with economic development in the Port Arthur area. Again, please adopt the proposal for decision. I believe John Beard was going to speak. I know he was having some technical difficulties, but I'll pass the remainder of my time to him.
Thank you, Mr. Porter. Mr. Beard, are you with us?
Yes, I am.
Good morning, sir. Go ahead when you're ready.
Good morning, first of all, and thank you, Chairman Neerman. Also, the commissioners, TCEQ staff, and the executive director. My name is John Beard. I'm the founder and CEO of the Port Arthur Community Action Network. And I ask that you uphold the decision that was made by the judges regarding this case. Some of the issues and matters being brought before you have already been settled several times over. But what we're asking for here is just as Mr. Porter described. We're asking for some relief. We're asking for some help. We're in an area that is already oversaturated in its airshed in terms of industrial pollutants. Some of the worst pollution in the entire state of Texas. The largest serial polluter in all the state of Texas. Oxbow calcining is located in that adjacent community, which I don't live
Mr.
very
Beard,
far from.
I'm sorry to interrupt, but we need to please confine your comments to evidence and information that was in the record.
Okay, thank you. But we are surrounded by pollution from numerous sources, and the cumulative effect of that pollution affects people like myself. I am an affected party due to health issues that I and my family are concerned with, and my neighbors and others. And we're asking that you do exactly as was said earlier, to protect the lives and health of people in this community. What we're asking for is simply to use the best available technology to make these reductions that can be done and should be done to protect an area that's already overburdened. We've shown you the information, we've given you all of the facts to it, and they lend themselves to proving what we're saying. So once again, I ask that you consider our position on this, to protect the lives and health of people in our community, because we're already overburdened, and we don't need any more, even if it's a little bit, and even if they say it's going to outperform. We don't know that. We know what we know, which is what's already here, and that is that we're already overburdened, and we don't need any more. And we ask you for your consideration and your approval of what the courts have already decided. Thank you.
Thank you, Mr. Beard. Colleagues, any questions for Mr. Porter or Mr. Beard or their other colleagues?
No, thank you.
All right. We'll hear next from the Executive Director's Office.
Good morning. Good morning, Commissioners, General Counsel, Public Interest Counsel. My name is Lorena Patrick with the Environmental Law Division representing the Executive Director. With me and available to answer questions is Benjamin Hansen and Chad Dumas with the Air Permits Division. The Executive Director respectfully recommends that the Commission adopt the Administrative Law Judge's proposal for decision with exception to the Administrative Law Judge's recommendations pertaining to the refrigeration compression turbines and the thermal oxidizers. The Executive Director's staff performed the necessary review to ensure that the draft permit meets all federal and state requirements and be protective of human health and welfare. The Executive Director respectfully recommends that the Commission issue the draft permit as prepared by the Executive Director's staff without change. Thank you, and we are available for questions.
Thank you, Ms. Patrick. Colleagues, any questions for the Executive Director's staff? Seeing none, let's turn to the Office of Public Interest Counsel. Mr. Arthur, good morning.
Thank you, Chairman. Good morning, and good morning, Commissioners. The ALJs recommend that the NOx limit for the refrigeration compression turbines be lowered to 5 ppmvd at 15% oxygen. As indicated in OPIC's closing brief, we support this change to the permit. OPIC is also not opposed to the ALJ's further recommendation that the refrigeration compression turbine CO limit be lowered to 15 ppmvd at 15% oxygen, and the thermal oxidizer NOx limit be lowered to 0.053 pounds per MMBTU. Thank you, and I'm available for questions.
Thank you, Mr. Arthur. Any questions for Public Interest Counsel? Seeing none. Mr. McDonald, you have not quite a minute, 20 seconds for rebuttal.
That'll be plenty. As I mentioned, the record in this case overwhelmingly supports approval of the application. It sounds like there's no dispute as to before you today about whether this permit should be issued under what circumstances. I think the real question is how to exercise your judgment as it relates to the lowered emission limits that we view are beyond BACT, that are not supported by the technical review and the other information and staff's own review of this permit. We do think they exceed BACT limits. Nevertheless, we're going to install equipment that we believe can achieve it.
Thank you. So, colleagues, here are my views. Of the issues that we referred, the protestants offered evidence only on BACT, and there were 5 different analyses or applications of that. Beginning with fugitive emissions, optical gas imaging has not been required in a similar permit, nor has it been demonstrated to be workable in operation at a similar facility. So I agree with the ALJs that the applicant met its burden to show that the required LDAR program is backed and not OGI. I also agree with the ALJs that backed does not require a total enclosure of the ground flares and that applicants' proposed flares constitute backed. And I agree that the proposed emission limits for the power generation turbines also satisfy backed. The issue about Freeport LNG was raised, but I don't think that that's an apt comparison because that facility operates in a combined cycle mode. So let me pause right there and see if there are any additional thoughts or different thoughts on either the flares or the fugitive emissions or the power generation turbines.
Were you about to say something?
I'm in agreement.
Okay, as am I.
Okay. Turning to the thermal oxidizers, I disagree with the ALJs that the controls do not need to be demonstrated in practice to be considered in the backed analysis. The technology should be demonstrated, and the record lacks evidence of LNG facilities with thermal oxidizers operating at 0.053 pounds per million BTU. I think the applicant demonstrated that 0.06 pounds per million BTU is backed. However, since the applicant will accept the 0.053 limit, I suggest that we keep it even if it is beyond backed. Thoughts on that?
I would agree.
I agree, and just to speak generally on backed, I think it is consistent with our agency's interpretation that backed is it must exist out there, and where requirements in individual permits may go beyond that, those typically reflect voluntary agreements or situational explanations, don't necessarily move the needle in backed until there is proof of that technology in use for a like facility That's the existing standard we rely on, and that's consistent with agency practice.
Thank you, Commissioner. Turning to the last application, the refrigeration compression turbines, again, I disagree with the ALJs. Again, a backed analysis requires a demonstration that the control technology is achievable. The ALJs have based their backed analysis on the NOx limits and permits issued to Golden Pass LNG and Rio Grande LNG. Those facilities are not yet in operation and haven't yet demonstrated what is or is not achievable. As for Dominion Cove Point LNG, that facility operates in a different manner. That's the combined cycle mode. In addition, it's subject to more stringent limitations, the layer controls. So I don't see that facility as demonstrating achievable backed for the application that's before us. As for the cost argument, which turns on the inlet concentration of NOx, the applicant used the concentration that was guaranteed by the manufacturer, and that is 9 parts per million volume dry. At that concentration, an SCR is not cost effective, and I think that the guaranteed inlet concentration is a more appropriate baseline than the higher concentration that was adopted by the ALJs. As for carbon monoxide, if we don't have an SCR, oxidation catalyst would not be cost effective, so we should not, in my opinion, adopt the carbon monoxide limits proposed by the ALJs. So those are my views on backed as it applies to the refrigeration compression turbines. And let me check in with y'all to see how you came out.
I'm in agreement.
Likewise.
All right, as for transcript costs, I would not change the ALJ's determination. As for the referral that was raised, I want to mention that we referred this for an effectiveness determination for Mr. Beard based on his alleged community engagements that were near the proposed operation, not because of the location of his residence and not because of what may have been shown in any modeling. It's become a moot issue since we've now had the contested case hearing. I just mention it as a caveat that I would not look to this case as any sort of precedent for an effectiveness determination. And let me pause there and see if there are any thoughts before we move to a motion.
Well said.
No?
All right. So to make the changes, colleagues, that I've suggested, we'll need to amend numerous findings of fact, conclusions of law, and at least one ordering provision. And rather than rattle that off and read it to you, what I'd like to do is hand you a prepared written motion. I propose we take a short recess and give you a chance to review that, connect the dots, form any questions, and then when we reconvene, I'll read it and we can discuss it and go from there.
I appreciate that. Thank you.
Okay, let's take a 5-minute recess. The time is 9:55 and we are in recess. Time is 10 a.m. We're back after a 5-minute recess. Colleagues, do you need more time, or have you had ample time to sort through that? Okay.
I'm good.
Any comments before I read this? Because I would prefer not to have to read it twice.
I prefer that too.
Okay, and I'll leave.
I'm in agreement.
I'll leave this. We can have discussion on the tail end of it as well. I just
Yeah.
want to make sure we're ready to go. All right. So I have a motion. Colleagues, I move that we adopt the ALJ's proposed order with the following changes. And bear with me because this is quite lengthy. A, amend finding of fact 52 to state, quote, if the analysis demonstrates that the identified emissions reduction options is proven to be operational, obtainable, and capable of reducing or eliminating emissions from the facility and is considered technically practical and economically reasonable, the applicant must propose an overall emission reduction performance level that is at least equivalent to that of the newly identified options, end quote. For inclusion for the purposes of including all the elements that must be considered in a backed analysis. B, amend finding of fact number 62 to state, quote, using a lower baseline emissions inlet value has the effect of increasing the cost of a control option, making the control option less cost effective, end quote, to more accurately reflect that the increase in costs is not an inappropriate manipulation of the calculation. C, add new finding of fact number 64A to state, quote, Dominion Cove Point LNG is the only LNG facility in the United States that is currently operating under a permit that limits NOx emissions to less than 9 ppmvd for its refrigeration compression turbines. That facility is located in an ozone non-attainment area in Maryland and operates its turbines in combined cycle mode, end quote, to reflect the evidence in the record. D, add new finding of fact number 64B to state, quote, although Golden Pass LNG and Rio Grande LNG have permitted NOx emission limits of 5 ppm VD at 15% oxygen, since neither of those facilities have been constructed, their NOx emission limits have not been demonstrated in practice, end quote, to reflect the evidence in the record. E, amend finding of fact number 65 to state, quote, the use of selective catalytic reduction or SCR technology on gas-fired refrigeration compressor turbines at LNG export facilities is not well proven, and only one LNG export facility has installed and operated SCR technology on gas-fired refrigeration compressor turbines, end quote, to reflect that only one LNG facility currently in operation is utilizing SCR technology on its refrigeration compressor turbines. F, amend finding of fact number 70 to state, quote, turbines equipped with the DLN 1 plus can achieve 9 ppm/VD NOx, end quote, to more accurately reflect the evidence in the record. G, amend finding of fact number 71 to state, quote, using a baseline inlet emission rate of 9 ppm/VD, the estimated cost to reduce NOx emissions with use of SCR range from $22,510 to $23,633 per ton. This cost effectiveness range exceeds the TCEQ's NOx threshold for economic reasonableness used with back determinations for NOx, end quote, to reflect the appropriate baseline emission rate for the turbines with DLN1 plus and the cost assumptions for use of SCR based on EPA's Air Pollution Control Cost Manual, 7th edition, the current EPA guidance for such calculations. H, delete findings of fact numbers 72, 73, 77, and 78 to reflect the evidence in the record that the ALJ's proposed reduction in the NOx and CO emission limits for refrigeration compression turbines have not been demonstrated in practice, and the use of SCR to control NOx emissions is not cost-effective when using the appropriate baseline emissions rate. I, amend finding of fact number 74 to state, quote, backed for the NOx emission limits on PALNG's refrigeration compressor turbines is 9 ppm/VD at 15% oxygen on a 24 rolling hour average, except during periods of maintenance, startup, and shutdown, end quote, to more accurately reflect the evidence in the record. J, add new finding of fact number 76A to state, quote, Pecan failed to rebut the prima facie demonstration that use of an oxidation catalyst to control carbon monoxide emissions is not cost-effective, end quote, to reflect the findings of the ALJs. K, add new finding of fact number 78A to state, quote, although Rio Grande LNG has a permitted carbon monoxide emissions limit of ppm/VD at 15% oxygen, since that facility has not been constructed, its carbon monoxide emissions limit has not been demonstrated in practice, end quote, to reflect the evidence in the record. L, amend finding of fact number 79 to state, quote, backed for carbon monoxide emissions from PALNG's refrigeration compressor turbines is the use of good combustion practices to achieve an emissions limitation of 25 ppm/VD at 15% oxygen, end quote, to more accurately reflect the evidence in the record. M, amend finding of fact number 95 to state, quote, although Lake Charles LNG is permitted for thermal oxidizers with a NOx emissions limit of 0.053 pounds per million BTU, since that facility has not been constructed, its NOx emissions limit has not been demonstrated in practice, end quote, to reflect the evidence in the record. N, delete finding of fact number 97 to reflect the evidence in the record that Lake Charles LNG's thermal oxidizer NOx emissions limit has not been demonstrated in practice. O, amend finding of fact number 98 to state, quote, a NOx emissions limit for thermal oxidizers of 0.053 pounds per million BTU satisfies BACT requirements, end quote, to reflect that this limit is within BACT as established in the TCEQ's Tier 1 BACT guidelines. P, amend finding of fact number 99 to remove the phrase, quote, to meet BACT, end quote, to reflect that even though the applicant has agreed to the ALJ's lower NOx emissions limit for thermal oxidizers, BACT can be met at the limits originally proposed in the draft permit, and because the protestant did not provide any evidence that the ALJ's proposed limit has been demonstrated in practice. Q, delete conclusion of law numbers 21 through 25 because the TCEQ's and EPA's BACT guidance documents are non-regulatory and do not establish binding legal requirements, and because the proposed conclusions of law exclude important elements of a BACT analysis, the absence of which may lead to a misapplication of the BACT standard. R, amend conclusion of law number 26 to state, quote, consistent with the Texas Health and Safety Code, section 382.0518, and 30 Texas Administrative Code, section 116.111A2C, the facility will use BACT with consideration given to the technical practicability and economic reasonableness of reducing or eliminating emissions from the facility, end quote, to reflect that the evidence in the record demonstrates that the NOx and carbon monoxide emission limits for the refrigeration compression turbines in the draft permit satisfy BACT. S, amend conclusion of law number 30 by deleting the first two bullet points to reflect that the evidence in the record demonstrates that the NOx and carbon monoxide emission limits for the refrigeration compression turbines in the draft permit satisfy BACT. And finally, T, amend ordering provision number 1 by deleting the first two bullet points to reflect that the evidence in the record demonstrates that the NOx and carbon monoxide emissions for the refrigeration compression turbines in the draft permit satisfy BACT. I further move that we issue the executive director's draft permit as modified by the commission from the dais here today, and that we adopt the executive director's response to comments. Colleagues, that's my motion. Is there any discussion?
I'd be willing to second the motion, but I'll second the motion then.
I think the only discussion I really wanted to have was just to point out that this is a good example of the BACT process working as intended. And there's moving pieces that over time, factors in our BACT analysis do change. And we see that where emission inputs for certain.
Wrong, guys. You're on the wrong side of the law. You're on the wrong side of the people.
Mr. Levin,
Chairman,
please.
You're doing backwards looking back. You know you're doing it, and you're wrong. And you're on the wrong side of the law on this, and you're the wrong side of the people. And shame on you for not listening to your judges and doing a tiny thing that would
Mr.
reduce
Levin,
NOx for the people.
Please,
You
sir,
know that, John.
please. Colleagues, the motion has been made and seconded. Is there any additional comment?
No?
All those in favor say aye.
Aye.
Aye. The motion carries. Why don't we take a short recess? The time is 10:11 and we're in recess. I'll tell them when we come back.
Do you want to take it out?
Do you want to take a break? Yeah. right. Time's 10:14. We're after a short break. Ms. Smith, I'll ask you to please call the next item.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order on remand concerning the application by the Port of Corpus Christi Authority of Nueces County for TPDES permit number WQ 000525300 to discharge treated effluent from a proposed marine desalinization plant. As a matter of housekeeping, we have a motion for continuance that was filed yesterday, and I would recommend that we allow each party to address the commission for 2 minutes regarding that motion, and that we recess after that.
That works for me. So we'll have 2 rounds here. We will hear the motion and arguments on the motion. We'll take a recess. And then after we come back, we'll go through the same cycle of parties and hear the arguments on the PFD, if there is a PFD to be considered at that point. So, Ms. Smith, do you want to tee up the motion and call?
The protestants.
Okay. Good morning.
Good morning, thank you very much. Craig Bennett with the law firm of Jackson Walker, representing Port Wayne. Can't hear you.
Craig, will you make sure that Mr. Bennett, make sure that light is on?
Yeah, it's
Green on here.
There we go.
There we go.
Okay.
I didn't touch it.
Okay, start from the top. We'll reset the clock.
Okay.
Good
thank
morning.
You. Craig Bennett with the law firm of Jackson Walker, representing Port Aransas Conservancy and other protestants in this matter. We filed a motion yesterday because on Friday, the Environmental Protection Agency submitted a letter indicating that this matter was not ripe for determination, identifying a number of concerns, re-urging their interim objection, and asking that certain things need to be done before this could be a valid NPDES permit. And they made clear that if the commission took action on this at this point in time without their concerns being addressed, this would not be a valid NPDES permit. The prior objections filed by EPA are in the record. They're in the record as PAC Exhibit 59R and 89R. And so this was just the follow-up to those, which had made it clear that they had raised objections, that the EPA had raised objections, had expressed concerns, and felt that those needed to be resolved under the memorandum of agreement between TCEQ and EPA before you could take final action on this. And the EPA letter identifies all of the various provisions of the MOA. Because that was filed on Friday, we felt that it was appropriate for you to consider that to determine whether you should, in fact, remand, allow the executive director to take those actions, or at least consider and address how you needed to respond to that EPA letter. Because if you take action at this point in time, we believe the EPA's position, as very clearly stated in the letter, is that it won't be a valid NPDES permit. And to avoid that sort of environment and situation, we felt it appropriate to continue your consideration of this matter and then consider how to appropriately proceed. And we certainly have arguments about how we think it should proceed. We indicate in the motion that we think it should be, the record should be reopened, and the letter admitted, and the executive director given the opportunity to address all of those concerns raised by EPA before you take final action in this case. Thank you.
Thank you, Mr. Bennett. Colleagues, any questions for Mr. Bennett? All right, let's hear next from the applicant.
Chairman, Commissioners, Douglas Allison, and I am here representing the Port of Corpus Christi. With regard to this discrete issue, I think I want to first say that we have, of course, tremendous respect for the role that the EPA has played and will continue to play. We certainly have tremendous respect for the TCEQ and the effort that has gone in from the TCEQ and their staff and attorneys to get us to this point. With regard to the specific letter that was filed on September 2nd by the EPA, it outlines essentially the same concerns that they articulated as much as probably about 8 or 9 months ago. And to be candid, one of the concerns that they've outlined includes a desire to see, I think, the permit in its final form so that they can then address some issues. That's not going to happen until we get past this threshold. And of course, I say that not anticipating this tribunal's or this commission's ruling. But respectfully, we believe that we have to go forward, that it has been a robust, spirited fight for 4 years. We're pleased to be here. We ask that we be allowed to go forward, understanding that there are concerns by the EPA that we will continue to work through. Thank you.
Thank you, Mr. Allison. Colleagues, any questions for Mr. Allison? Thank you, sir. Let's hear next from the Executive Director's staff.
Good morning. I'm Kathy Humphreys, representing the Executive Director. The Executive Director continues to assert that EPA's objections...
We cannot hear you.
We check your mic and start from the top.
This fan over here is very loud for us.
Good morning.
I'm not sure if we can turn the, just bear with us for a moment, Ms. Humphreys. I'm not sure if we can turn that fan off or if you can maybe change seats so you're in a position to hear better. We'd like everybody to be able to hear the testimony. Or get a better mic. Let's try it, or use 2 mics.
Does this mic work better? Okay.
All right, much better. Ms. Humphreys, from the top.
I'm Kathy Humphreys, representing the Executive Director. The Executive Director continues to assert that EPA's objection to the permit was untimely and the termination of a review waiver is not retroactive. This is supported by item 4C8 in the Memorandum of Agreement between TCEQ and EPA. The Executive Director also continues to assert that the minor classification rating, which was determined using the EPA's minor-major rating worksheet, is the correct classification. Since receiving delegation from EPA for implementation of the NPDES program in 1998, the TCEQ has never considered water treatment waste from desalinization plants to be processed wastewater. EPA has never disputed this determination until now. Regardless, the Commission would like, if the Commission would like the Executive Director's staff to take additional time to work with EPA to attempt to resolve these disputed issues, staff would ask that the item be continued.
Thank you, Ms. Humphreys. Colleagues, any questions for Ms. Humphreys? Mr. Arthur, Mr. Wayne, good morning.
Hey, good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. As you just stated, I'm Sheldon Wayne for the Office of Public Interest Counsel. And with respect to the motion that's pending before the Commission, OPIC has been concerned with the EPA's correspondence with TCEQ in this matter, and those concerns remain. OPIC has previously recommended denial of this permit, and that continues to be our recommendation. As discussed in our closing argument before SOA, OPIC finds that there is significant legal risk in issuing a permit over EPA's interim objections, especially given EPA's position that the permit will not be a validly issued NPDES permit. EPA's most recent letter confirms that risk, stating that it has not received the proposed permit for review and detailing concerns regarding substantive requirements in the draft permit, including those designed to protect water quality and aquatic life. OPIC likewise shares these same substantive concerns, and our recommendation of permit denial was in part based on them. OPIC believes that the permit denial is the most equitable resolution to what has become a rather lengthy and protracted process. However, if the Commission finds itself inclined to grant this continuance, we would support it, all three, the continuance, remand, and then also reopening of the record to allow the Executive Director an opportunity to address the EPA's concerns. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. Colleagues, any questions for the Office of Public Interest Counsel? All right, well, we appreciate the parties' arguments on the motion. We're going to take another.
I think I do have one question before we go. And I think this will be best for the ED's staff to answer. If you can, just kind of walk me through the timeline of when EPA objects, whatever's in the record, okay? But just help me understand, lay out what's happened here and why EPA would still have a concern at this point. And you might answer this, but kind of a follow-up question is, I guess when does EPA usually review? I think it was Mr. Allison stated something about EPA wants to review the final permit, and it's not, final until it's final. Is that normally what happens? Is that how it normally goes back and forth between us and EPA? And if we can't go there, then
And Commissioner
don't.
Lindley, I think anything inside the record, and I think we'll probably let all parties share their views of what the timeline looks
Yeah.
like. And Mr. Bennett, I'll give you credit for hopping up there.
Yeah.
Go ahead, sir. We'll let you up there.
Yeah,
We'll
go ahead,
treat
yeah.
it in the spirit of a rebuttal on
Thank you
your
very
motion
much.
argument.
I very much appreciate that. The only thing I want to clarify is the EPA letter makes very clear that they want the proposed permit, not the final permit. It says it numerous times, that they need the opportunity before final action is taken by the TCEQ. So I just want to clarify that point. The letter's very clear on that.
Thank you, Mr. Bennett. Mr. Allison, why don't you go while Executive Director staff is checking their notes?
While she's looking for that.
Yes, sir.
The way that I've read the letter from EPA, just to give that some balance, is that they want to see it in final form. And there's some recommendations from the ALJ, and I think we all recognize that's going to require you all's action or recommendations or reaching a conclusion and a permit then in final form. I agree with Mr. Bennett that they have asked for time to review it in final form before its issuance. But my point is that it seems to me that even if we were going to oblige that request, that we would need to have our hearing today in order to get over that hurdle so you can do what you think is the right thing to do. And then you'll handle that procedurally with the EPA how you all see fit.
Okay, to restate that or synthesize it, what we're looking for is a proposed permit, but in final form, ideally the commission having worked through all the issues to get to that final form. All right. Ms. Humphries.
The distinction between a draft permit and proposed permit, I think, is part of the crux of this. A proposed permit is a permit that has been through public notice, public participation, and we have a, quote, final draft permit. So right now, we don't have a proposed permit to send to EPA, even if that was the commission's choice.
Thank you. And did you have an answer to the timeline question?
Yes, EPA sent the first letter, their first objection to us in November. I don't have the exact date. I'm sorry? Just before that. So the process has been going on since late 2021. Or unless I have my file.
Mr. Bennett, do you have an answer?
I think I have it.
The initial letter was in September of 2021. They sent a follow-up letter in March of 2022. They sent a third letter in September 2nd, 2022. And the basis of their initial letter indicating that they had never received notice of the application, which is why they were just then responding, because it had been treated by the executive director as a minor permit. EPA noted that in their position, in their review of the applicable rules, it was a major, and they should have received notice of it, but never did. And that's why they filed the letter in September.
Thank you, Mr. Bennett. Mr. Allison, any
I just want to
corrections or comments on that?
I think all his dates are correct, but I think he missed one. There's one in December 15 of 2021 also that attached the EPA comments, okay?
Okay.
So I think the September one in 2021 was the withdrawal of the waiver, followed by the December one, and then I think there was a March one, and then the September one, and if I'm missing any, I apologize.
Thank you, Mr. Allison. I saw Mr. Bennett nod in agreement, so I think we're building our timeline here. Ms. Humphries, did you have something to add?
That corresponds with my notes as well.
Okay. Commissioner Lindley, other questions about timelines?
No, thank you all.
Okay.
I have a timeline question. Could I get a repeat of the one date of when EPA communicated the rescinding the waiver on review? September 2021. Is that the point that EPA would point to and suggest that our desalination permits from that point, and they think they can communicate a retroactive obligation, but we think it really is only from that point forward, we'll comply with the waiver and begin sending our desal permits to your review. earlier in the process per your request under the MOC, but prior to this date, is this the fundamental disagreement? EPA interprets that they can reach back and also apply that rescinding the waiver to permits that we already had in process? And if so, what was the status of this permit before us in this matter on that date?
Yes, that's my understanding of EPA's concept, that they can retroactively request review. At the time we received that first letter, we had already been through the first hearing on the merits. We had been before you. It had been remanded, and we were in the process of the remand application.
Thank you.
Thank you, Ms. Humphries. Other questions? Mr. Wayne, are you all right with all this?
I can just add that the timelines presented, we do agree with those timelines. We've looked those up, and they appear to be correct. I would also just like to briefly reiterate that EPA's request to review the proposed permit prior to final action of the TCEQ. And so I think that's very important that you do remember that EPA wants the permit prior to a final decision by the commission on that permit itself. And the EPA would also be supplied with the administrative law judge's proposal for decision. And from there, they should be able to see which modifications the administrative law judges are proposing to incorporate into that permit. And so we think that they would have sufficient information to review both the proposed permit and the record to come up with, to address any objections and any concerns that the EPA does have prior to final agency action.
Thank you, Mr. Wayne.
I have a question for OPIC. Have you reviewed the memorandum with EPA and the provision that Executive Director points to that is the point of disagreement with EPA? What's OPIC's view on whether EPA can retroactively impose requirements on us?
Quite candidly, I have not reviewed that memorandum, and so I wouldn't be able to give you OPIC's position on whether that review can apply retroactively to permits that are already in-house.
Thank you.
All right, I think what we're going to do at this time is take another recess to give us an opportunity to consider the motion. So with that, the time is 10:31. Should I identify a time that we'll reconvene? Why don't we say 10 minutes? Is that going to be enough? 15? All right, let's do 15. 15 plus 31. So the time is 10:31. We'll reconvene in 15 minutes. We are in recess. Time's 10:49. We're back after a short recess. Colleagues, this is a lot. There are a lot of moving pieces. And to get right down to it, I could use more time to think about the moving pieces. So I'm going to move and we can discuss it, but on my own motion that we continue the pending motion and the PFD to the next agenda. That will give me the time that I need to sort through this and make some decisions. The time may also be useful to the parties in terms of sort of fine-tuning exactly what they're seeking. So that's my motion. What are your thoughts about it?
Today's just wild. My initial thoughts are I just don't really. I would be fine moving. I would prefer to move forward today, but I could. If you guys want to delay it 2 weeks, that's fine. I wouldn't want to necessarily go further than that. I just am having a EPA to me jumped in very late in the process. And so that's not going to change, that is what it is. And my interpretation of what's happened here is that EPA's guidance document said one thing, and it appears to me the ED followed that in thinking that this was a minor. And now maybe they think differently. I hate to put words in their mouth, but it seems to me that the guidance document was followed. So I'll stop there. If you want to do 2 more weeks to the next agenda, that's fine. I wouldn't want to go longer, but it is a lot.
Commissioner Janeka.
I'm of two minds of this. On the one hand, I'm not sure what a continuance does to improve the outcomes and how any further consideration or maturation of the different parties' take on this issue could occur, given that it does seem to me we're at a bit of a unique regulatory point in time, and there's some real open questions where EPA has taken a different interpretation on their underlying guidance and the timing applicable in a memorandum that we had with them, and where there's room for disagreement, we always have to continue that conversation, but it puts us at odds in the fact that we have this permit come back to us, and when we have an obligation under state law to act on and respond to the questions and ultimately issue or send back, deny, take further action on the permit as appropriate. And I think that I'm not opposed at all to the continuance and taking the time to think about it, and I'm comfortable doing so. I think my immediate initial reaction, frankly, was a lot closer aligned to yours, Commissioner Lindley, in that it seems to me that the clear, obvious path forward is the one where we seriously respond and ask EPA's concerns in this program area, this permitting area, and continue to really push and press to try to understand what they're going to be asking for and when they will need to know those data. It's very important that we communicate back to EPA and respond quickly so that they don't feel that they've been backed into a corner where they can't fully act or fully consider our permitting actions. I don't think that that's all what has occurred, and I think that our staff's interpretation of the guidance and the path that they've taken on this particular permit has been appropriate, and the timing of EPA's changing course on specifically with the exception in the guidance, it puts us in a very difficult position. So I'm comfortable either direction.
Well, let me ask you this, Commissioner Janeka, do you have an opinion on the protestants' motion?
I think specifically in terms of introducing into the record the latest communication from EPA and where that factors into the motion,
and the remand and the
have a little more
totality
comfort
of the motion.
I don't know that I saw the urge or the need in remand in terms of timing-wise, EPA communicating their difference of interpretation on the guidance. I don't think that that should not obligate us to stop the clock and put in the extra delay and let them have the chance to act on the permit. And the remand really feels like it falls into that policy box.
Commissioner Lindley?
So-
Yeah,
Sounds like, you know, I don't want to put words in y'all's mouth. We're in agreement, a remand is not what we feel comfortable doing, but you want 2 more weeks to think about, and if that's not accurate, chime in. 2 more weeks to think about all of this.
yeah. My thoughts are largely aligned with yours, but this is important. And I have not, carefully considered all of the moving pieces. I haven't laid my eyeballs on all of the documents. I haven't parsed those. I haven't decided. I have an inclination, but I haven't really made myself comfortable with the direction I'm leaning. And so that's why I would like the additional time.
Well, I agree, it is very, very important. I show the next agenda as the 22nd, and if that's what you want to do, I can, like I said, I can get there. Just bringing it up as an old business item then.
Could I offer a pragmatic solution that might help everybody? And that is
Check your mic, Mr. Bennett, and I'm going to allow
Okay,
you and
sorry.
Mr. Allison to
And I think-
talk about the wisdom of my motion to continue this item.
I'm going to go out on a limb here and guess that Mr. Allison may agree with me on this, that maybe a pragmatic solution is you take the arguments of the parties, so you have both the oral arguments of the parties on the merits of it, and you can also consider what you want to do with the EPA letter, and then you have everything, and if you do continue it, you're more prepared you don't have to have extensive arguments at that time, and you have a fuller picture of everything that you're considering.
Well, there's a thought, too. Mr. Allison, did Mr. Bennett predict correctly?
Not that we talked during the break, but yes.
Okay.
We think that might have some benefit to you all, to the EPA, and to the ability for you all to ultimately handle whatever it is you need to handle in terms of some of those procedural and, to the extent it's substantial issues also. So yes.
Yes, sir. Thank you. Bear with us, we're consulting multiple lawyers. I feel bad for the people who are here on item 24. You should be at brunch right now. All right, folks, we're actually still on the record. I think we've heard from the lawyers. I was not hearing a lot of interest in Mr. Bennett's motion. So I'm going to suggest that we not consider that. I think I will take Mr. Bennett and Mr. Allison up on their offer to make their arguments, as well as ED and OPIC, make their arguments on the proposal for a decision. When we reach the end of the arguments, then I'd like to reconvene with my lawyer, or perhaps we can discuss the appropriate path forward on that, with the notion that we may still want to continue this, or not, but just one step at a time. Does that work for you?
Yes. So do we need to take a formal?
No, I don't believe we do. I saw Commissioner Janeka nod in agreement, so let's take the parties' arguments on the PFD, beginning, Mr. Allison, with you.
Thank you, Chairman. Commissioners, Doug Allison. I got a brief introduction a moment ago, but I have a little more time. I want to make sure I do introduce to you also Ernest Wotering. He is co-counsel for me. He is present. Also present is our chairman for the Port of Corpus Christi. I represent the Port of Corpus Christi. And our chairman, Charlie Zahn, is also present. And also our chief in terms of environmental concerns, Sarah Garza, is also present. There are other people here for the port, and I appreciate them being here. I think I mainly want to highlight that from the standpoint of kind of really sharing with you that from our perspective, we understand the gravity of a responsibility that I think we've taken on here. This is the first large-scale seawater desalination project for the Texas Gulf Coast. It is obviously the discharge permit that we're here about today, and we are seeking that discharge permit so that we can go forward with development of the project. Of course, it was 2011 when the legislature gave some pretty strong language for there to be a push for alternative water sources. I'm sure we're all familiar with those quotes. I don't have to tell you, absent the recent rain, we were staring and may still be staring drought in the face with many communities in Texas, especially South Texas. We're probably at the leading edge of this in our community in many ways because of the need in South Texas, and so many of those showers, quite frankly, go north and east of us, and we are a community that is often drought-stricken. It is a huge responsibility in our mind for us to have taken this on, but as a political subdivision of the state of Texas, we feel like we are a perfect entity to have the responsibility put with us and with this commission, and of course with the EPA, to move forward. I do want to make sure I do thank the TCEQ, you all, of course, and staff. Executive Director, I will tell you the staff has been just outstanding in their effort and their contribution from a technical standpoint. I do stand before you to just ask that you issue the permit, and it is we understand it is certainly your prerogative how you handle the recommendations of the administrative law judges, those being a additional 2 PPT limit at 100 meters, and also additional monitoring of the percentage of effluent at the zone boundaries, and then also that ultimately a monitoring program be developed. I will tell you from our standpoint, we have such confidence in that location and our proposed path forward that we are willing to do all of those things, so we made no objection or exceptions to the ALJ's proposals. We are so confident in our location that we feel we can not only meet but exceed those parameters. How that will have implications to other desalination, we leave all of that to you, and I apologize, I'm hitting the mic twice now. How that will impact other desalination projects, we would leave that to you to balance. Of course, you could do it here and not make it precedent or however you wanted to handle that. With regard to this particular permit location, the reason that we have such a high degree of confidence is, quite frankly, it is a location that the most important thing, and believe me, we've all learned, and we've learned together. And I want to mention this. We've learned together because we have the benefit of seeing what's happened in California, where there are many desalination facilities. We don't need to pretend like we're the first one to ever do it. We're just first for a large-scale one in Texas. They have a large-scale one in Florida. They have many in Spain. We worked closely on our expert team. We had the person, Dr. Nathan Knott, who is the person who did the before and after studies for desalination in Australia, multiple plants. Of course, Saudi Arabia leads the world in terms of the number of desalination facilities that they have. But we have such confidence in this location because there is, and rule one, and it makes sense, there is such tremendous water exchange with the tide coming in and out twice a day that we have basically a mixing of ambient condition, ambient salinity, ambient water from the Gulf of Mexico, coming in and out twice a day, 47 billion gallons a day. The current keeps an area turbulent and allows mixing, which is the key to having it dispersed quickly. That is what will allow us, we believe, to not only meet but exceed the parameters that have been laid out by, first of all, the draft permit and then ultimately the administrative law judge's recommendations. We've had this looked at, of course, from, and there's a huge record. I'm truly such a process person. I believe in process. The protestants have made this a better permit. Their objections have made it a better permit. Their concern for the environment, along with ours, has made it a better permit. It will meet and exceed the requirements of what California does permitting-wise. Carlsbad, for example, has a limit of 2 parts per thousand at 200 meters. The proposal here is 2 parts per thousand limit at 100 meters. So because of the unique and high degree of mixing in this area, we believe that it should be issued. We've had it looked at. We've certainly had samples of the analysis at the intake. We've had samples taken from the intake, evaluated it fully through the process, had modeling done by both sides, most of which agrees with each other, and then ultimately had marine biologists and the ecotoxicologist do a thorough review. We believe the literature supports it. All of that is in the record. There's multiple studies that were done pre-litigation that had nothing to do with litigation. And then there were studies done by both parties in the context of litigation. We followed the EPA guidelines in terms of the test species we selected. And we believe that is the right way to do it because otherwise, quite frankly, you get too much variability in test results. So we did that with the accredited lab. Thank you. We did that with an accredited lab and believe that we have a permit that will truly perform for the people we represent, which are the residents first and foremost of Nueces County, San Patricio County, and we believe for the entire state of Texas. Thank you.
Thank you, Mr. Allison. Colleagues, any questions for Mr. Allison? Mr. Allison, I actually have a question. Earlier, I expressed some concern that I haven't laid my eyes on all the language and parsed all of the language. To be clear, what I was really referring to is EPA's expression of their concerns about the program. Is it a major, is it minor issue? So that is a conversation that TCEQ is going to have with EPA. But it's also relevant to this permit, of course. Do you have any thoughts on if we were to issue a permit, how you would navigate that with EPA?
Well, I think that kind of the way we view our role right now is that we filed for this permit in, I think, 2018. We've fully engaged the process, we believe, in good faith with the TCEQ, and since the time of the withdrawal of their waiver, we've engaged with the EPA. We want to continue to do that. We've not taken a position that it's major or minor, and don't really intend to do that. I think what you said a moment ago is right. That's probably a conversation for you all to have with them, and we respect that. I think at this point, back to something you said earlier too, kind of one step at a time. I think it's probably incredibly important for you to hear argument, so I appreciate you doing that. And then to evaluate all those moving parts you're talking about and see what the EPA has requested and see if there's a way to thread this needle where they can continue to be heard, and we certainly want that, and where ultimately the permit, and they've asked for 30 days, I think that's in their letter, but that ultimately the permit is issued in good standing with the TCEQ and the EPA. But we're certainly here, we understand it's your permit to issue, we made the application to you, and so we're certainly here asking for it at this time.
Thank you, sir.
Thank you.
I have a question, actually. I appreciate
Another one, at least one.
your question, Chairman. It
Take it
never
away.
fails. It helps prod my mind, and that's the specific request of the 30-day review for EPA. Do you have any concerns for further delays on this permit matter? Are there fair? I do not have a question.
I think we probably need to step away from the more recent EPA letter because it is not in the record, and so it shouldn't be considered, and I'd caution everybody not to consider it in the context of the permit. Thanks.
Thank you, Ms. Smith. Is there a question in there that?
I think the discussion has answered my question to the extent I need. Thanks.
I will say, I think some of the earlier letters will be informative to your question. So some of the information in the earlier letters that are on the record may be helpful.
Thank you, Mr. Allison.
Thank you.
Mr. Bennett.
Give me a moment to get
Sure.
set up. Okay, thank you very much. Good morning. It is still morning, isn't it? As you know, I'm Craig Bennett on behalf of Port Aransas Conservancy, but I'm also speaking today on behalf of the other protestants in this case. For the last 15 years, I have taught Texas Administrative Law at the University of Texas Law School. I also currently teach the same class at Baylor Law School. My students generally come in pretty cynical about the regulatory state in our country. They often think that we've lost common sense, we elevate form over substance, we are beholden to special interests, and I disagree with them. I routinely disagree with them, and I hope today proves me right. This is not a difficult case when it comes to common sense. The port wants to put a desalination facility on Harbor Island. Okay, fine. That's perfectly fine. But then they want to discharge 100 million gallons a day of hypersaline wastewater right into a narrow channel adjacent to Harbor Island that is one of the most aquatic life zones in the state. 9 of the most qualified aquatic life experts and water quality experts in this state have testified this is a terrible idea. Even Texas Parks and Wildlife Department has expressed concerns about this, and the EPA has objected as well, and has indicated this will not be a valid NPDES permit if you issue it currently. But there's a simple solution.
Again,
Well, that's in the interim objections that were in the record. Exhibit Pack 59R and 89R both have the interim objections where they make that same statement. I just want to be clear. I'm not referencing the September 2nd letter. But there's a simple solution that virtually everybody can agree upon. Put the desalination facility on Harbor Island. That's fine. But then run the discharge offshore into the Gulf. The port's already proposed to have the intake out in the Gulf. There's no reason they can't run the discharge out into the Gulf. If they did that, PAC would support it. Audubon, Texas would support it. The experts at UT Marine Science Institute and the Hart Research Institute would support it. It simply makes no sense to discharge 100 million gallons a day into a narrow channel that is one of the most sensitive aquatic life zones in the state when there's a simple solution, putting it offshore. The Texas Parks and Wildlife and the General Land Office have indicated that offshore discharges are better, and they proposed that to the legislature. So just like you remanded before to allow the port to fix the application, we think you should remand again and give them an opportunity to change this discharge location, put it out into the Gulf, and they would find a tremendous amount of support for that and not opposition, because we're not opposed to desalination. But if you determine it's not appropriate to change the discharge location on remand, then you ought to deny this permit, because that's exactly what the port did when you remanded it the first time. It's important to remember the context of this remand. Last year, after 2 judges recommended denial of this permit on 6 separate grounds, you remanded to allow the port to provide site-specific information to support their proposed discharge. But that's not what the port did. Rather, they ignored the remand order. They submitted a new application with new modeling. They changed the discharge location, they changed the diffuser, they did new modeling, And we challenged it early on. We said, that's contrary to the remand order. We asked the judges to certify a question to you to address the scope of the remand. They declined to do so. So rather than a simple remand hearing like you probably expected, we had a hearing that was twice as long, 2 weeks, with double the witnesses, with almost 20 expert witnesses testifying. This is, but there was no notice to the public about this. There was no notice to Parks and Wildlife Department, no notice to EPA. This is entirely contrary to the notice requirements for these types of proceedings. Despite all of this, amazingly, the port's amended application still has some of the most basic elements wrong, including the discharge location, which I'll talk about a little bit more in a moment. You're setting precedent. As Mr. Allison noted, this is the first large-scale desalination facility in Texas. You ought not let such a poor application and such a kind of slipshod record set the precedent for a proceeding like this and for future proceedings. And to be clear, although the judges have recommended approval of the permit, they have done so only after acknowledging many issues with the evidence in the record and whether it establishes a protective environment for water quality. And so to cure these concerns, the judges have recommended a 2.0 parts per thousand limit on salinity at 100 meters out, and to conclude that this will fix any problems. While we support a 2.0 PPT permit limit, without any monitoring requirements, which do not currently exist in the draft permit, that limit alone will not be protective of water quality or the environment. And without any enforcement, that will not be protective. As noted, the port has still not settled on a discharge location. This may be the most shocking thing of all. In its amended application, the port changed the discharge location, and they identified their new location with a specific latitude and longitude. Then when we demonstrated that that specific latitude and longitude would not support the proposed discharge, on rebuttal, they backed away and said, we don't have to use that location. And that to me is shocking. And if you think I'm exaggerating, let me read the testimony from their expert. He said, quote, precise latitude and longitude of the diffuser ports will not be determined until the final design of the diffuser is completed, end quote. He also testified the diffuser design memorandum does not specify an exact latitude or longitude for the diffuser barrel and ports, as these will be determined for the final design. Neither the port nor the ED have put any limit on how far away the discharge can be moved. Your rules require compliance with the instructions for the application, which requires the latitude and longitude to 6 digits, which means it can only be off by about a foot. The evaluation of the impacts of the proposed discharge is based upon the specific location of the discharge. And Chairman Neerman, you specifically stated at the last open meeting in this case, quote, I appreciate the burden this matter has already placed on all of the parties, but in my view, the weight of the equities and the better policy is to remand the matter so that we can determine whether the proposed authorization is indeed protective based on more precise data inputs. And so that's what I would propose, end quote. So you made clear you wanted more precise data for the proposed discharge, but that's not what you got. In fact, now the port backs away and say they don't even have to identify the discharge location with any specificity. But that flies in the face of your rules, it flies in the face of common sense, and it flies in the face of your own witness's testimony, who testified on the record about changing the discharge location the following, quote, I believe that would require a whole new application. I would need to double check, but because our reviews are site specific, if they move the outfall, that would basically be going back to the beginning, end quote. That's your witness. So if you grant this permit today, or on the record before you now, you're agreeing that an applicant does not have to use the specific discharge location they've identified in the application, and that they can, on remand, interpret your remand orders however they want, regardless of what your statements say is the purpose of the remand. I don't know why you would want to set such a precedent. The way this application has been processed, honestly, is a head-scratcher to me. It certainly has left EPA scratching its head, wondering why much of the basic information needed to evaluate this massive proposed discharge has not been provided yet or is simply wrong. Consider just the following facts from the record. The port's amended application says the discharge will be in 90 feet of water, but the map attached to their revised application shows the discharge point in 65 feet of water. Getting accurate data for the discharge location was one of the reasons you remanded in the first place. And the judges even note the evidence shows it's in 65 feet. But then they ultimately say, well, a 2.0 PPT will be okay. But the fact of the matter is, the application as it sits here before you today says it's going to be in 90 feet. And the judges have already said in their PFD, no, it's actually in 65 feet. I can't imagine why things are that sloppy after this long of a time, 4 years, as Mr. Allison has noted. The amended application also modeled the discharge at 26 feet from the channel bottom. But then, in rebuttal testimony, the port indicated it would actually only be 4 to 6 feet from the channel bottom. It may be more, maybe less, but the height above the channel is critical for modeling. And again, why are we learning this on rebuttal after a remand after 4 years? It's just shocking to me. At the last open meeting, the port said there was a localized eddy that would help mixing. Now they say there isn't an eddy. In the first hearing, the port, the ED, and the PAC used the brine module for core mix modeling. Yet on remand, the port and the ED now claim it's no longer appropriate. Not surprisingly, the brine module shows worse mixing than the model now used by the ED and the port. Your own witness has said that additional reviews are conducted for major facilities, yet they were not done here, even though EPA has made very clear that this is a major facility under the federal definition that your agency uses. The anti-degradation review, honestly, was very unclear, I'll just say, to be generous. An anti-degradation review is supposed to ensure that salinity gradients are maintained to support aquatic life uses and that any degradation to salinity gradients must be no more than de minimis. Yet when questioned at the hearing, the anti-degradation reviewer could offer no definition for de minimis or what a salinity gradient was, and could not identify any formal methodology for the supposed weight of the evidence analysis. The EPA has also noted concerns about the anti-degradation review and has requested additional information to support it. These are just a few of the glaring problems with the application and the draft permit. I could cite more, but I want to conclude with this. The decision you make today, or in a few weeks, or in a month, or whenever you ultimately decide this, will have the potential to dramatically affect one of the treasured bays and coastal economies in the state. Authorizing a discharge into a narrow channel presents far too great a threat to aquatic life and the environment, and it violates your own rules. You should deny the port's application. Then the port can pursue the pragmatic, sensible solution that satisfies everybody's concerns, including Parks and Wildlife and GLO, by placing the discharge offshore into the Gulf. Thank you for your time today.
Thank you, Mr. Bennett. Colleagues, any questions for Mr. Bennett? Thank you, sir. We'll hear next from the Executive Director's Office.
Good morning.
Oh, I'm sorry. We had, I apologize. James King was supposed to be, we had reserved some time for James King.
Yeah, I'm sorry. I did,
I apologize
I
for
saw
that.
that note. Just a couple of minutes, Ms. Humphreys. Mr. King, are you with us?
Yes, I am.
Good morning, sir. Go ahead when you're ready.
Okay, I'm ready. Good morning, Chairman Neerman and members of the commission. My name is James King. I'm a sixth-generation Texan who grew up in Corpus Christi. My wife and I have a house on the Aransas Pass Channel, and we are both founding members of Port Aransas Conservancy. Chairman, as you know, we hiked together years ago in the Davis Mountains. And for more than 20 years, I worked to help establish the Davis Mountains Preserve and many other significant conservation lands around the state. Recently, my wife and I were executive producers of Deep in the Heart film and worked across the state with Ben Masters and his amazing crew highlighting Texas' natural diversity. The dolphin scene in the film were in the Aransas Channel right near the discharge point and done from my boat. We and thousands of other Texans are not radical or crazy, but informed citizens relying on you to do your job to protect our business, our homes, and the environment. We are not a national group opposed to all development, but are local citizens who care so much about this area that we raised over $5 million across the state and work with the most respected scientists who know this area better than anyone. And those scientists all, let me repeat, all agree this is a terrible location for a discharge. We're not anti-business. The business here in Port Aransas is tourism and activities like fishing, swimming, and birding. The port knows that nearly everyone would support this project if the port would just move the discharge offshore into the Gulf, like all the discharges of all the desal plants that Mr. Allison talked about. An offshore discharge is the best option, and we stand ready today to work with the port to achieve that outcome. Let's table this permit and work together with the port to fast-track an offshore solution that will meet everyone's interests. PAC will either work with the port and TECQ for an offshore solution, or we will continue to oppose this major discharge into the heart of a sensitive ecological system with all the tools at our disposal. We'd rather work toward a sensible solution that spends the time, rather than spending the time fighting a terrible proposal. I hope you give us that chance. Thank you.
Thank you, Mr. King. Colleagues, any questions for Mr. King?
No, thank you.
All right, Ms. Humphries.
Good morning, Commissioners, General Counsel, Public Interest Counsel. I'm Kathy Humphries with the Environmental Law Division. With me today are Bobby Salahi and Harrison Malley of the Environmental Law Division, and Shannon Gibson, Katie Cunningham, Peter Schaefer, James Mahawk, and Michael File from the Water Quality Division. The Executive Director's staff reviewed the application submitted by the Port of Corpus Christi of Nueces County for a new TPDS permit and drafted a permit based on the application. The Executive Director supports the ALJ's finding that the Port of Corpus Christi met its burden of proof on all referred issues and the ALJ's recommendation to issue the proposed permit with the revisions proposed by the ALJs. Therefore, the Executive Director respectfully requests that the Commission adopt the ALJ's proposed order as amended by the ALJs in their exception letter and issue the draft permit with the ALJ's revisions, and we're available for questions.
Thank you, Ms. Humphries. Colleagues, any questions for Ms. Humphries? Mr. Wayne.
Thank you, Commissioner. Thank you, Chairman and Commissioners. If I may begin, and I'd like to first just ask for permission. Commissioner Janeka, during that break, we were able to review that memorandum of agreement, and we do have some perspective to answer your question if that would be appropriate at this time. And we believe that we can do so only referencing items which are currently in the record for this matter.
One moment.
I'm not sure I understood that. I thought I heard a reference to a letter that's not in the record that you can address in a fashion without addressing the letter. I'm sorry.
I guess. I believe that I can answer Commissioner Janeka's previous question regarding that memorandum of agreement through reference to the September 2021 letter from the EPA, which is in the record in this matter.
Give me a moment. Okay. Mr. Wayne, I feel like we've, for our purposes today, at least so far, we've moved past that issue. That said, I don't have an objection to your using your time that way, so long as you confine your comments to the record.
Absolutely. Thank you,
Okay,
Chairman.
go ahead.
And I'll be very quick with our response. We simply wanted to add maybe a little additional perspective. Commissioner Janeka, you'd asked us about the language which is contained in that memorandum. That same language is quoted in the EPA's September 20th of 2021 letter to TCEQ, and that language reads that and this is specifically section 4.c.8 of that memorandum of agreement, which states that the EPA does not relinquish the right to petition the TCEQ for review of a permit action or inaction because of a possible violation of federal or state statutes, rules, and policies. The EPA may terminate a waiver as to future permit actions in whole or in part at any time by sending the TCEQ a written notice of termination. Therefore, we view that that language of future permit actions is subject to interpretation. It's somewhat ambiguous there. And from our perspective, the EPA's September 2021 letter makes clear that the EPA's own interpretation is that the draft permit at issue here is subject to a future permit action, namely being a decision on whether to grant, deny, or grant that permit with modifications. And therefore, the EPA may validly rescind its waiver of this draft permit and require its review at this time. With that, I'll move on to our substantive comments regarding the contested case hearing and proposal for decision, the matter before you today. So with respect to the Commission's consideration of that proposal for decision and the related record in this matter, after examining the evidence and the argument presented, OPIC re-urges the position taken in our closing brief, that the Port of Corpus Christi Authority's application should be denied. Due to the complexity of the issues presented and the permit itself, OPIC will use its time to discuss the disputed issues of most significance. Chief among those, and pertinent to the inquiry of whether the proposed discharge will adversely impact the marine environment, aquatic life, and wildlife, is whether the discharge will cause significant lethality within the zone of initial dilution. OPIC found convincing protestants' testimony that the discharge would cause a salinity increase, resulting in significant lethality of aquatic organisms. And in particular, OPIC is concerned with the effect of multiple stressors causing or contributing to latent mortality of larvae that pass through the zone of initial dilution. OPIC was also not convinced that the discharge will not cause adverse impacts to benthic organisms that live in the depression near the proposed outfall. The protestants presented evidence that a high salinity plume will exist on the floor of the ship channel up to a mile from the discharge and may result in drops in oxygen levels that could harm benthic organisms. Additionally, related to the question of whether the discharge will adversely impact the marine environment and the aquatic life, is whether the Cormix modeling used to simulate the dispersion of the effluent discharge in the water body is accurate. In OPIC's view, the Cormix modeling suffers from a number of issues, which potentially render it inaccurate. For example, because the model requires schematization, it is unable to account for the actual bathymetry of the ship channel, such as the slope of the bank the diffuser will be placed on, or variations in the channel's depths, which are especially relevant here because of the large depression on the channel bottom near the diffuser. These inherent deficiencies, in combination with Cormix's large margin of error, made OPIC question its reliability. Also, OPIC was not persuaded by the port that an eddy does not occur at times near the discharge. We acknowledge that the frequency of the occurrence of this eddy remains undetermined, but are not satisfied that the port has proved that an eddy does not occur, at least occasionally. And while we're unable to evaluate the impact of an eddy based on the available record, it does add to the uncertainty of the modeling results and creates the possibility for aquatic organisms to be recirculated through the highest concentrations of effluent present in the channel. OPIC also questioned the adequacy of the ED's determination that no degradation of the receiving waters will occur, given that it relied, at least in part, on the Cormix modeling results, which OPIC has questioned the accuracy of. Ultimately, after considering all of the evidence, OPIC came down on the side of recommending denial of this permit. However, we readily admit that this was not an easy decision, and we can see how the judges arrived at a different conclusion. OPIC agrees with the judges that at the very least, it is necessary to modify the permit before issuance. In particular, inclusion of an overall limit for salinity would go a long way towards ensuring that the permitted discharge is protective of water quality and animal life. If included, a permit limit of no more than a 2 parts per thousand increase over ambient at 100 meters appears to be the most reasonable based on the record. Additionally, it appears to be reasonable to add affluent percentages at the aquatic life and human health mixing zones. Such additions would create a more protective permit with greater enforceability. Finally, OPIC would also support the ALJ's recommendation to add a monitoring plan requirement to the permit to validate the mixing efficiency once the facility is operational. The port has agreed to work with TCEQ to develop this plan if necessary. OPIC agrees with the ALJs that inclusion of a plan would be helpful, especially recognizing that this is the first large-scale coastal desalination plant to be built in Texas. Therefore, if the Commission were inclined to grant this permit, OPIC respectfully recommends inclusion of the modifications as recommended by the proposal for decision, and that the Commission sustain and incorporate those proposed changes as laid out in the judge's reply to the exceptions to the proposal for decision. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I don't have any colleagues, any questions?
I appreciate that position and also the answer to the earlier question.
Thank you, Commissioners.
Thank you. Mr. Allison, to you for rebuttal.
Yes, may I inquire as to my time?
5 minutes, 50 seconds.
Thank you. I do appreciate the opportunity to give some more information and to offer rebuttal. I feel like, and I want to tell you this, it's almost like a deja vu. Realize that these are the arguments we've heard for years. These are the arguments that we've heard over and over and over again in front of the administrative law judges. These are passionate arguments, and I will tell you, in all candor, there's passion on this side for the environment also with the port. I know that Chairman Zahn he lives in Port Aransas as well, and he has been there 52 years, I think, okay? There's no more avid fishermen than people on this side as well. It is a fabulous area, and it will need good stewardship, and technology and science must, though, inform our decisions. There's a lot of passion on both sides, but we adopted a phrase very early on this that let science inform our decisions, and we did that not because we came up with that. We did that because the executive director for University of Texas Marine Science Institute, Bob Dickey, on one occasion, and another communications person from the same university on another occasion, said, let science inform decisions, and there will not be any adverse impacts from a discharge at the proposed location near Harbor Island. That is in the record. UTMSI was supportive of it before some of their members now are against it. And the reason that they were supportive of it is the same reason that we support it, and that is let science inform our decisions. There's a list of pre-litigation scientific papers not connected with any advocacy, whether it's the Robertson case, and we all focused on red drum, and then we focused on red drum larvae as being most sensitive, and then we focused on 3-day-old red drum larvae as being the most sensitive. And so we all focused on that being sort of the surrogate for making these evaluations. And there's a Robertson study from 1988 that lets us know up to 45 ppt that there's no adverse effects. Even their own expert, Dr. Gregory Stuntz from Heart Institute, who did a study in 2015 for the city of Corpus Christi, reached the conclusion that that marine life in the Corpus Christi Bay system has natural tolerance for salinities from 28 to 42 ppt, and he did not offer an opinion about whether or not higher than 42 ppt would have any adverse effects. Again, that supports their own expert information, supports issuance of the permit. There's multiple studies. There's a Bronner study where they show recruitment up to 60 ppt with redfish, red drum. There's another study from Casala that is done by a couple of different people with the University of Texas A&M University, Corpus Christi. That study says that between 33 ppt and 43 ppt is the best hatch rate and growth for red drum larvae, up to 43 ppt. This facility, this discharge permit, and please understand, when you're doing this testing, you're subjecting the larva for 24, 48, and 72 hours. This facility, actually the discharge plume will occupy about 2% of the channel, none of the Lydian channel, which is where most of the reproduction occurs, none in the Aransas channel, distinguished from the Aransas Inlet. And when you look at the ship channel, the plume will only occupy about 2% of the channel, and the time of exposure is seconds or minutes, never hours, and certainly not days. So the data overwhelmingly supports that there will not be any adverse impact. Otherwise, we would not be here. We would not even be asking to be here. So with all due respect, I understand that there are good gotcha moments in the testimony. The location, yeah, when you start saying we want it to a decimal point, I'm bad at that. When we start saying we're going to do it to a decimal point that's equal to 6 feet, and the expert witness says, well, we're going to put it on the slope because, of course, it's a channel. And when they actually build it, maybe it'll be here. And they go, oh, well, you're moving it now. That's not the sort of gotcha that is real science. We designed it, and they're right. The depth of the discharge is important. Everybody knows that's at 64, 65 feet. There is a scour hole of 90 feet out in front, but there's no mystery. The bathymetry has been meticulously documented in the area. Everybody knows the bottom. Those are gotcha points. I could go on and on, but I will tell you that in order to understand why the ALJs did what they did is they had the entirety of their records studied in front of them. They spent 2 weeks listening to testimony and pouring through it. You can't look at well, I'm going to juxtapose this one statement with this one and reach a conclusion. These are ALJs that, let's be candid, they've proven themselves willing to deny the permit. But what we did is we went out, rigorously studied the bathymetry, rigorously looked at the depth at 5 feet increments of the salinity, how it changes, because it is a very mixed environment. That's good. In other words, there's variation naturally occurring because there's a lot of mixing going on in that area naturally because of the heavy currents. They looked at all of that, and when you put it all together, I just didn't hear it. 1 minute or 0?
I'll ask you just to finish up. She
Okay.
called time, so just
Okay.
take a moment to finish.
Well, when you look at the data in its totality, it is overwhelmingly, if you let science govern and take the passion out, it is overwhelmingly in favor of granting the permit. So we make that request.
Thank you, Mr. Allison. I think we had contemplated perhaps taking a recess at this point, but give me a moment. Colleagues, my thoughts are still gelling on this, candidly, so let me check in with you and see what your thoughts are. Commissioner Lindley. And just for context, I'm still contemplating, perhaps continuing the item, not more than 2 weeks, acting. Those are some of the things on the table anyway, so.
I would probably be comfortable either moving and trying to take action today or waiting 2 weeks. But again, as I've said, I don't want to wait longer than 2 weeks. There is a lot to digest. I don't disagree with that. And, having a little more time to do that is okay. But it's not going to change anything in the record for me. I'm not sure my mind will change substantially. But if you want, as we stated, this is a big deal, right? And if we need 2 more weeks to make sure everyone feels comfortable with their decision, I can do that.
Commissioner Janeka?
I think it's probably wise to take a continuance for 2 weeks, given that the good reminder for all of us, I think the ultimate scope of inadvertent escalation among all of us in this permit matter, it points to a very unhelpful place for the public. And I think where our agency's conversation with all the stakeholders here in the room and across our state and across our country is a critical one. I think there's one obvious clear key stakeholder that exercises a unique and different view of it, and where a clear and obvious action to us today may complicate relationships and bring more pushback and more objection from other outside parties, absent an extra 2 weeks to cogitate and better understand some of the sensitivity points in this issue. And I appreciate the fact that we've just today been able to start to review some of the latest complexities of the issue. I think a 2-week continuance is appropriate.
All right, well, let me just re-up my motion then. I move that we continue this item until the next agenda.
I second.
Let me say I really appreciate all the work that went into this today. I appreciate the parties' arguments. Right. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you all. Ms. Smith, when you're ready, you can. Do we want to call the next item, or do we need a recess?
I could probably, I don't know, I can push through 1 or 2 more before I need a
All
recess.
right, let's keep going. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by FM 2920 Land Company LTD for new TPDS permit number WQ00159770001. The parties have been notified that the commissioners will not hear oral argument but may ask questions. And those who have been signed in on this item will be noted for the record.
For the benefit of those who aren't familiar with our process, we have a 2-part analysis for considering requests for contested cases. First, we consider whether the requesters have met all of the procedural and substantive requirements to be entitled to a contested case. And then, assuming that at least one requester has done so, we then consider which issues are appropriate for referral. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. In determining who is an affected person, we consider the requester's statement of their personal concerns and their proximity to the regulated activity together with the nature of the proposed discharge. In callings on this item, we have numerous hearing requests. All of them are from individuals. I found that 6 requests met all of the procedural and substantive requirements for a contested case hearing. I would grant a hearing to Judy and Colin Allison, Kevin and Cindy Crane, Karen and Scott Hill, Danielle Camus and Michael Redden, Kenny and Betsy Gardner, and James Paul Long and Renee Sanchez. The remaining requesters, in my evaluation, either failed to submit timely comments or they failed to articulate a personal justiciable interest, that is a personal concern that's relevant to the permit. So I've concluded that we have to deny the remaining requests. And let me pause there and see
I'm
how
in
you all
agreement.
came out.
Likewise.
Yeah.
Okay, turning to the issues, I've identified 4 referable issues. The first is whether the draft permit adequately addresses nuisance odors. Then whether it is protective of water quality and the existing uses of receiving waters, whether it contains adequate provisions to protect the health of the requesters, as well as aquatic and terrestrial wildlife, and finally, whether it contains adequate monitoring and reporting requirements. Colleagues, how did you all come out on the issues?
I'm in agreement on those as well.
Those captured in mine.
Okay, I would set a hearing duration for 180 days, and I think with that, we may be ready for a motion.
I could make one.
Go ahead.
I move that we grant the hearing requests of Colin and Judy Allison, Kevin and Cindy Crane, Scott and Karen Hill, Danielle Como and Michael Redden, Kenny and Betsy Gardner, and James Paul Long and Renee Sanchez, that we deny the remaining hearing requests, that we refer the matter to SOA for a contested case hearing on the following issues. A, whether the draft permit adequately addresses nuisance odor in accordance with 30 TAC Section 309.13E. B, whether the draft permit is protective of water quality and the existing uses of the receiving waters in accordance with the Texas Surface Water Quality Standards. C, whether the draft permit contains adequate provisions to protect the health of the requesters and aquatic and terrestrial wildlife. And D, whether the draft permit contains sufficient monitoring and reporting requirements. And finally, that we specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item when you're ready.
Item number 4 is the application by the City of Dripping Springs for a major amendment to TCEQ permit number WQ001-4488001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So again, colleagues, we have a two-part analysis. Part 1 is who gets a hearing, and Part 2 is about which issues are referred. And again, requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Associations can establish a right to a hearing if the interests they seek to protect are germane to the organization's purpose and the association identifies at least one member who would have standing in their own right. Governmental entities with statutory authority or other interests relevant to the application may also have a right to a hearing. Colleagues, we received 6 requests on this item, and I'll begin with the governmental entity. That's Hayes Trinity Groundwater Conservation District. That district is tasked with protecting groundwater. It's raised relevant and material issues relating to the protection of water wells and other issues. So their interests are very much at play here. I would grant the district's request. Save Our Springs Alliance is a nonprofit organized to protect the Edwards Aquifer and Hill Country watersheds. SOS raises relevant material issues relating to groundwater and surface water quality, interests that are germane to its purpose. SOS identifies Mr. Bill Bunch as well as Chris and Karen Hill as members who would have standing in their own right. Because the Hills' own property reside and recreate within the area subjected to surface irrigation, they would have standing in their own right. So I would grant SOS's request. Protect Our Water, another association, did not identify a member who would have standing in their own right and did not state its purpose. I would deny its request. Scott Emerson, an individual, failed to identify personal concerns that are relevant material to the permit. I would deny his request. The same goes for Cynthia Wesson. She failed to identify a personal concern. I would deny her request. Jennifer Schaefer, in my view, did meet the procedural and substantive requirements to be entitled to a contested case hearing, so I would grant her request. And let me pause and see how you all came out on the parties.
I came out on those 3 parties as well.
Likewise.
All right, turning to the issues, I believe the affected persons have reserved the following issues. First, whether the draft permit is protective of the requester's health. Then, whether it's protective against effluent affecting surface waters or groundwaters. Whether it contains adequate monitoring and operating requirements to avoid unauthorized discharges. Whether it complies with siting, buffer zone, and effluent storage requirements to protect against over-application or runoff. Whether it contains adequate effluent limitations and testing requirements to prevent nutrient accumulation and leaching past the root zone, whether the applicant met the notice requirements, and finally, whether the applicant submitted adequate information relating to the location of wetlands, floodplains, the depth of groundwater, size and location of the irrigation sites, and the size of the buffers. So that is how I would identify the issues.
I'm in agreement.
Those aligned with all the issues I found.
Okay, I would deny the requests for reconsideration. I would include an ADR referral, and I would allow a hearing duration of 180 days. That sounds all right.
I'm in agreement. I've got a motion. I would move that we grant the hearing request of Save Our Springs Alliance, Hayes Trinity Groundwater Conservation District, and Jennifer Schaefer. That we refer the application to SOA for a contested case hearing on the following issues. 1, whether the draft permit is protective of the requester's health. 2, whether the draft permit is protective of water quality by preventing wastewater effluent from discharging into surface waters or adversely affecting groundwater. 3, whether the draft permit contains sufficient monitoring and operating requirements to avoid unauthorized discharges into surface water or groundwater to maintain proper operations and protect recharge features. 4, whether the draft permit complies with applicable siting, buffer zone, and fluid storage to protect against over-application and runoff of treated effluent from irrigation areas as set forth in 30 Texas Administrative Code, Chapters 309 and 222. 5, whether the draft permit contains adequate effluent limits and testing requirements to prevent irrigation area nutrient accumulation and leaching past the rooting zone. 6, whether the applicant substantially complied with the applicable notice requirements for the application. And 7, whether the applicant submitted adequate information relating to the location of the wetlands, floodplains, depth of groundwater size, and location of irrigation sites, and the size of buffers to support the issuance of the draft permit. I would move that we further refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, that we deny the remaining hearing requests and requests for consideration, and that we set the hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next items.
Items 5 through 8 will be taken up together. They are the consideration of fiscal year 2023 proposed assessment for annual costs for the Watermaster operations in the Rio Grande Water Division, the South Texas Water Division, the Concho River Watermaster Program, and the Brazos Watermaster Program. The Executive Director's staff is here to present these items.
Good morning. Barely, just barely, but good morning. And I'm not sure we can hear you that well, so you might, get the green light.
There you go.
Yeah.
Good morning, Chairman, Commissioners.
I'm sorry to interrupt you, but can you pull the mic just a little bit closer? There we go.
Hey.
All right. Thank you, sir.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Jose Pepe Davila, and I'm the Watermaster Section Manager with the Water Availability Division. With me today are Cole Malley with the Environmental Law Division, Stephen Kino, and Eliana Spade with the Water Availability Division. Staff are here to request the approval of the fiscal year 2023 assessments for the 4 Watermaster programs, Rio Grande, South Texas, Concho, and Brazos Watermaster Program. We have prepared the assessments to cover costs of the Watermaster programs. This year, South Texas is to increase by 5.7%, Rio Grande program by 9.2%, Brazos program by 13.7%, and the Concho program by 5.5% due to salary and fringe increases. Notice of the proposed assessments was provided to all water right holders in June. Water right holders were encouraged to attend and participate in the July Watermaster Advisory Committee meetings. At the July meetings, assessment budgets were presented and feedback from the committees was considered. Ultimately, all 4 Watermaster Advisory Committees voted to recommend approval of the assessment budgets before you today. Thank you. We're available to answer any questions you might have.
Thank you, Mr. Davila. I have none. Colleagues, any questions?
No, thank you.
Ms. Smith, has anyone signed in to speak?
No one signed in on this one.
All right. Mr. Arthur, what say you?
Chairman, thank you. OPIC supports approval of the ED's recommended budgets for the Rio Grande, South Texas, Concha River, and Brazos Watermasters. Thank you.
Thank you, sir. Well, we have a recommendation from the ED. We have endorsement by OPIC. The Watermaster Advisory Committees have all approved of this, so I'm ready to move forward.
I agree.
Likewise, adding on one last thing, and that's just the kudos to the Watermaster staff for doing all the good work, preparing the numbers at a time of the year where I think it's work has increased for y'all quite a bit. So doubly appreciate that.
Hear, hear.
I move that we approve the Concha River, Rio Grande, South Texas, and Brazos Watermaster budgets for fiscal year 2023 and issue the executive director's 4 proposed orders assessing the annual costs of those Watermaster programs.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 9 is the consideration of the executive director's findings and recommendation on whether a watermaster should be appointed for the following basins: the Upper Brazos River, the San Jacinto Brazos Coastal Basin, the Colorado River, and the Brazos, Colorado Coastal, and Colorado Lavaca Coastal Basins. The executive director's staff is here to present this item.
Good afternoon, Mr. Davila.
Good afternoon again. Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Jose Pepe Davila. I am the Watermaster Section Manager with the Water Availability Division. With me today are Cole Malley with the Environmental Law Division, Kim Nygren, and Ilana Spade with the Water Availability Division. In accordance with Chapter 11, Subchapter G, Sections 11.326 G and H of the Texas Water Code, the Executive Director is required to evaluate each river basin that does not have a water master program at least once every 5 years to determine whether a water master should be appointed. We are to report the findings and make recommendations to the Commission. During fiscal year 2022, we evaluated the Upper Brazos River, San Jacinto Brazos Coastal, Colorado River, Brazos Colorado Coastal, and Colorado Lavaca Coastal Basins. The evaluation was based on the criteria and factors determined by the Commission. The 3 primary criteria evaluated were: 1, were there any court orders to create a water master? 2, have any petitions been received requesting a water master? And 3, have senior water rights been threatened? 2 letters were mailed to stakeholders throughout the basins on March 11, 2022, and May 13, 2022, to notify them of the evaluation process, as well as their ability to attend meetings and to offer comments. 3 stakeholder meetings were held in person on June 1st, June 2nd, and June 3rd. 2 additional stakeholder meetings were held virtually on June 7th and June 9th. During the comment period, 4 opposed comments and 1 in favor comment were received for the Upper Brazos Basin and the San Jacinto Brazos Coastal Basin. 27 opposed comments, 3 in favor comments, and 2 neutral comments were received for the Colorado River, Brazos Colorado Coastal, and Colorado Lavaca Coastal Basins. With no court orders or petitions to create a water master during the 2017 through 2021 period, as well as no repeated history of threatened water rights, the Executive Director recommends that the Commission not move forward on its own motion to create a water master program for the Upper Brazos River, San Jacinto Brazos Coastal, Colorado River, Brazos Colorado Coastal, and Colorado Lavaca Coastal Basins at this time. Thank you. We are available to answer any questions you might have.
Thank you, Mr. Davila. I have none. Colleagues, any questions?
No, great work.
Ms. Smith, is anyone signed in?
No one has signed in on this item.
Mr. Arthur?
OPIC agrees with the ED's recommendations, and we appreciate their evaluation and report of these findings. Thank you.
Thank you. Colleagues, I agree with the ED and OPIC. And any contrary thoughts?
I look forward to the results of the next review in 5 years unless we hear from community sooner asking us to take action in regards to watermaster duties.
Thank you, Commissioner.
Yeah.
No action is necessary on this item, so thank you. And Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is items 10 through 22, and the ED staff is here to present these matters.
Good afternoon.
Good afternoon, Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 10 through 22. The total assessed administrative penalties are $169,299, with $11,631 deferred, $32,408 applied towards supplemental environmental projects, and $125,260 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No, thank you.
Ms. Smith, is anyone signed in to speak?
On item 13, we have Mr. Owen Allison virtually, who's asked to speak.
Ms. Allison, are you there? Mr. Allison, my apologies.
Hello, my name is Danny Miller. I'm the city administrator. Owen Allison just stepped out. We didn't have anything in particular. We were just asked to sign here in case y'all had any questions for us.
I understand. I don't think we have any questions, but we really appreciate you tuning in and participating. And
then I guess on that note, we also have people signed in on 12 and 19 who are available for questions if the commission has any.
okay, colleagues, any questions?
No.
Seeing none. Thank you, sir. We appreciate you joining us. Mr. Arthur, what do you think?
OPIC supports issuance of these orders as proposed by the ED.
I do too, colleagues. I'm ready to move forward.
I'm in agreement, and I would move that we adopt items 10 through 22 as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Colleagues, I could actually use a recess now, too, if you're all right with that. Why don't we say 5 minutes? The time is 12:09, and we are in recess. All right, we're back. We're back. Are we back? Are we back?
We need them to turn on the lights, yeah.
We're back. We're not back. Electricity is so important. There we go. Now we have electricity. We're back on the record. After a short break, the time is 12:15. And Ms. Smith, I'll ask you to please call the next item.
Item number 23 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 307, the Texas Surface Water Quality Standards. The Executive Director's staff is here to present this item.
Good afternoon.
Good morning, or good afternoon, Chairman, Commissioners, General Counsel, and the Public Interest Council. On behalf of the Executive Director, I'm Lori Hamilton with the Water Quality Planning Division. With me are Jill Seckitts and Debbie Miller with the Water Quality Planning Division and Stephanie Scogan with the Environmental Law Division. This adopted rulemaking would provide a periodic public review and revision of the state surface water quality standards as provided for in the Texas Water Code, Section 26.023, and required by the Federal Clean Water Act, Section 303C. The Texas Surface Water Quality Standards were last revised in February 2018. The proposed rules were published in the March 25th, 2022 issue of the Texas Register. A public hearing was held on May 2nd, 2022, and the public comment period also closed on May 2nd. The rule team did receive public comments, and based on those comments, the rule team made the following substantive changes. Language was modified in Section 307.2G1 to specify that the options listed are the only options for expressing a temporary standard. The interim effluent condition that reflects the greatest pollutant reduction achievable with pollutant control technologies can be used if no additional feasible pollutant control technology can be identified, and a temporary standard can be expressed as the highest attainable interim criterion. Section 307.6C1, Table 1, the freshwater chronic criterion for cadmium was corrected, and the analytical method for free cyanide analysis has been incorporated into footnote 2. Section 307.6D1, Table 2, human health criteria for crysine and 1,2-dichloropropane were corrected, and the analytical method for free cyanide analysis has been incorporated into footnote 3. In Appendix B, Granger Lake is no longer being deleted, and 2 counties were added to the county column for San Marcos River. In Appendix E, the phrase site-specific criteria has been added to the 2nd and 5th sentences of the introductory paragraph. Footnotes in the parameter column were also revised for 2 existing entries in the watershed of segment 901 to clarify that the site-specific criteria are applicable to the area near a permitted outfall as opposed to the entire water body. Editorial changes were made to the description of Bullhead Bayou East in Appendix G. In addition, both the proposed pre-production plastic definition in Section 307.3 and proposed Section 307.4B8 that explicitly prohibited the discharge of visible pre-production plastic and provided a compliance mechanism were removed. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 307 of the Texas Administrative Code, the Texas Surface Water Quality Standards. Additionally, staff respectfully request authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Hamilton. I have none. Colleagues, any questions?
No, thank you.
Ms. Smith, has anybody signed in to speak? Mr. Arthur? Oh, good morning.
Good afternoon.
Afternoon, yes.
Good afternoon, Chairman, Commissioners, General Counsel, Executive Directors, Attorney, and staff. My name is Pranjal Mehta. I reviewed this rule item for OPIC. OPIC supports adoption of this rulemaking. Thank you.
Thank you, Ms. Mehta. Colleagues, I'm ready to move forward.
As am I. I have a motion. If we're ready, I would move that we adopt the amendments to 30 Texas Administrative Code, Chapter 307, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 24 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 299 regarding dams and reservoirs. The Executive Director's staff is here to present this item.
Mr. Samuelson, good afternoon. Good to see you, sir.
Good to see you. Good afternoon, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Warren Samuelson with the Critical Infrastructure Division. With me is Kelly Cook with the Critical Infrastructure Division and Harrison Cole Malley with the Environmental Law Division. The adopted rulemaking amended Sections 299.1, 299.2, and 299.7 of 30 TAC Chapter 299, Dams and Reservoirs. The adopted rulemaking would implement Senate Bill 600 from the 87th Legislature 2021 regular session related to requiring river authorities to submit information on their dams. And I might add, they did last year. We've had them on the website for a whole year. We're in the process of updating the website now with new information. House Bill 2694, 82nd Legislature 2011, and House Bill 677, 83rd Legislature 2013 related to exemption of dams. The adopted rulemaking will also make revisions to clarify language in the rules. The proposed rules were published in the April 15, 2022 issue of the Texas Register. A public hearing was held on May 17, 2022, and the public comment period closed on May 17, 2022. The rule team did not receive any comments during the public comment period. In conclusion, the staff respectfully recommends adoption of this rulemaking to Chapter 299. Additionally, staff requests authorization to make non-substantial revisions necessary to comply with the Texas Register requirements. Thank you. We're available to answer any questions.
Thank you, sir. Colleagues, any questions? No. Thank you. Ms. Smith, is anyone signed in to speak?
Yes, we have two people signed in. The first is Mr. Alex Ortiz. Oh, sorry, Ms.
Good afternoon.
My name is Alex Ortiz. So my sister and I were actually signed up to testify on the preceding agenda item, not this one. I don't know how that mistake happened.
I guess we had you signed in on the registration as being on 24, item 24, which is this.
Yeah, so.
I'm sorry for the error. What?
I'm not quite sure.
We actually, I mean, just by coincidence, we do have a public comment session that you could,
right. I mean,
that we could invite you to speak at that.
Okay. How much longer is that going to be?
It's the next item, and let me say thank you for your patience. It's been a really long agenda, and I'm sorry that you're stuck here at the end of it, but I really appreciate your patience. Okay. But that's a rule. Item 23 was a rulemaking. It was not a contested item.
Yes.
I don't. Is there a problem with commenters offering comments on the next item?
Just one moment.
Yeah, I know. Sorry about this.
You planned your day around this. I really want to hear what you have to say. Yeah. So we're going to figure out if and how we can make this work. All right, so the advice I have is that what we would like to do, Ms. Ortiz, is finish out this item 24, and then we'll call item 23 again and have a do-over.
Awesome.
I guess we do do-overs.
Thank you.
So thank you. We'll get back with you. All right, so I'm guessing there's nobody signed in to speak on this item 24, dam safety.
Correct.
All right, see none. Public Interest Counsel, Ms. Mehta, again?
Good afternoon again. I reviewed this rulemaking rule item for OPIC. OPIC supports adoption of this rulemaking. Thank you.
Thank you. Colleagues, this is real straightforward. rulemaking to implement legislation as well as to comply with the recommendation of the Texas State Auditor's Office. I'm ready to move forward with it.
Likewise, I will make the motion that we adopt the amendments to 30 Texas Administrative Code, Chapter 299, Dams and Reservoirs, as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you, sir. Good to see you all. Oh, I'm just going to interject something. It was either you, Mr. Samuelson, or Mr. Cook who taught me a very important lesson that seems to be one that's difficult for people to understand, so I want to repeat it as often as I can. A high hazard dam refers to how many people live downstream of the dam. A high hazard dam, that title says nothing about the physical integrity of the dam. It could be a fantastic dam that will be there until the end of time. It could be a lousy dam. But high hazard refers to the population downstream, not the integrity of the dam. So thank you for teaching me something, and good to see you all. Let's call item 23 again.
Going back to 23, which was the consideration of the adoption of amendments to the Texas Surface Water Quality Standards.
And we'll go straight to comments from interested persons. And Ms. Ortiz, I'm sorry we somehow missed you last time around, but go ahead and
no
state your name for the record, and then the floor is yours.
Yeah, my name is Alex Ortiz. I'm the Water Resources Specialist for the Lone Star chapter of the Sierra Club. The Sierra Club is the nation's oldest conservation organization and has been actively engaged in Texas water issues since 1965. I wanted to touch on several of the issues that the Sierra Club and our joint commenters raised during the public comment period. And the first is about sort of the statutory authority for this pre-production plastic pollution issue that was originally proposed in Section 307.4B8 before it was withdrawn. There seems to be a myth that this commission is somehow lacking in authority regarding the ability to actually regulate this plastic pollution. There need not be a specific directive from either the federal government or the state legislature in order for this commission to adopt such a regulation. Texas Water Code Section 26.023 clearly states that this commission has the sole and exclusive authority to set water quality standards for all water in the state. Additionally, as noted in the memo setting up this agenda item, it's very clear that there are expected recommendations that are not required by federal rule or state statute. If the commission were to intend to reject every revision not required, then this would be an effectively toothless process overall. I do want to point out that there are significant scientific justifications for the adoption of a pre-production plastic ban pollution, and I know you'll hear a little bit more about that in a second. But there's also this strange reliance on that same section of the Water Code 26.023 that says TCEQ shall develop standards based on all quality assured data obtained by the commission. That merely sets a requirement that this commission actually consider all the data it has. It doesn't set any sort of minimum data amount that the commission needs to have in order to inform a rulemaking. So I do want to make the point that this is something that y'all is well within your jurisdiction to adopt this ban in particular, and it's something that's going to have or would have really significant impacts for coastal communities, coastal wildlife, and for tourism industries along the coast. Moreover, withdrawing a provision like this that had pretty widespread public support, our joint comment letter included, I think it was 12 organizations that signed on, and we had over 500 comments submitted from Sierra Club members that actually called for this ban in particular to be strengthened. I do think that that's something that really should be taken into account, that this is a really, really big, important thing to Texans in particular. Aside from the plastic issue, I did want to touch on something that's come up a little bit today, and that's salinity gradients. TCQ has supposedly been gathering data on salinity gradients for the better part of 2 decades. The first time that Section 307.4G actually appears in its current form is in the 2000 Surface Water Quality Standards. And it says, because long-term studies by state agencies to assess estuarine salinities are still ongoing. it's been 20 years and they're still ongoing because that provision looks almost exactly identical now as it did 20 years ago. And prior to that, that provision in the 1997 standards read that salinity gradient maintenance is important for the continuation of balanced and desirable populations of estuarine-dependent marine life because weather is the dominant factor influencing salinity gradients. And I want to reemphasize that because we're well aware that the climate is changing and that we're going to see continued shifts in salinity gradients that are coming from factors well outside of our control. So being able to have the most effective baseline so that we're not actually shifting along with whatever continues to happen is really important. So setting those salinity gradient standards in a numeric fashion as soon as possible is really integral. And I think that's
3 minutes.
Oh, there you go. Okay.
Yeah, I'll
Any
ask
questions?
you to. Were you at the end of your comments?
Yeah,
Okay.
no, I'm
All right.
good. Thanks
Thank
for
you
your
for
time.
that.
I
I
appreciate it.
appreciate it. Colleagues, any questions? I'm seeing none.
Okay,
You raised
cool.
some important issues. I appreciate you being here today. Thank you. Ms. Smith, who's next?
Ava Ortiz.
And go ahead when you're ready.
Good afternoon, Commissioners. My name is Ava Ortiz. I am the Microplastics Fellow at Bayou City Waterkeeper, an environmental nonprofit organization focused on clean water and climate resilience across the greater Houston area. By removing your own proposal on pre-production plastic pollution, TCEQ is clearly indicating that the public's voice does not matter. Banning pre-production plastic pollution would have been a significant victory for all of Texas, which is why we urge TCEQ to adopt the proposed ban in Section 307.4b. I will now share my reasoning for the proposed ban. First, defining pre-production plastic pollution. In other words, nurdle pollution, microplastic pollution, they all describe the same thing. There's many names to it. They're all 1 to 5 millimeter pellets or nurdles in various size, shape, and color. You can find them all over coastal beaches, all over streams, all over Texas. Not just Texas, actually. They're a building block for larger products, polyethylene, polypropylene, and polystyrene, and they're just a few petrochemicals and additives used to make these building blocks. These additives, when introduced to the environment, wreak havoc. There's a common misconception that nurdles or pellets are chemically inert, meaning inactive, but that is far from true. Nurdles act as toxic sponges. Additives or pollutants and bacteria can adhere and become more concentrated on the surface of nurdles. The term for this is rafts. Nurdles acting as a vessel for these toxins. Examples include DDE, which is a type of pesticide, and PCB, which is polycarbonated biphenyl. Additives can also leach into their surrounding environment, polluting water quality, contaminating soil, and putting an organism at risk when ingested. Second is defining the environmental risks. There is a scientific justification for wanting to regulate pre-production plastic pollution. Nurdles are made from fossil fuels. It is time we start regulating pre-production plastic pollution. Nurdles are hazardous. As mentioned, they can leach their chemical composition into their surrounding environments and collect chemical additives on their surface, introducing harmful toxins. Environmental risks include degradation of water quality, threatening endangered species when ingested, and contaminating soil. The effects of ingesting plastic nurdles is diminishing appetite, damage to internal organs, and causing inflammation of the digestive tract and leading to starvation, worst case scenario. Thirdly are the human risks when it comes to nurdle pollution. Biomagnification and bioaccumulation are two words that get thrown around a lot. When talking about human health risks, biomagnification is the definition we would use. That is what affects us, eating infected food that has accumulated a dangerous amount of nurdle pollution in its system, or drinking contaminated water. Although the effects are still being studied, plastic nurdles or pellets are hazardous and should be treated as such. Health risks include damage to the nervous system, internal organs including kidneys, lungs, stomach, and other digestive organs, Endocrine disrupting chemicals are just one of the many risks. Nurdles around 10 micrometers are able to access all organs and cross the blood-brain barrier, meaning they can find a way to travel inside a pregnant person if need be. Imagine collecting microplastic made from petrochemicals inside your system. I don't think anyone wants that. One last point I would like to discuss is the term visible to the naked eye. Fossil fuels are not always visible. Pre-production plastic pollution is not always visible, but we know it is there, and unlike fossil fuels, which become non-existent one day, pre-production plastic pollution, nurdle pollution, microplastic pollution is never going away. It will outlive everyone unless we take initiative and put a ban on all plastic pollution. Thank you for your time.
Thank you, Ms. Ortiz. And Ms. Smith, who's next?
Shay Pearson.
Hello, Mr. Pearson.
Chairman Neerman, Commissioner Lindley, Commissioner Janeka, and General Counsel Smith, thank you for letting me address you all today. My name is Shay Pearson. I'm General Counsel for the Texas Chemical Council, and it is the TCC's position that the proper regulation of pre-production plastics cannot be accomplished through a simple clarification of the surface water quality standards, and supports the pursuit of a separate rulemaking for pre-production plastics based on additional scientific research and the development of a science-based numeric standard. TCC recognizes the importance of keeping pre-production plastics out of the environment, and the TCC is committed to providing its support and industry expertise to the Commission to develop effective and fair compliance standards for manufacturers. Thank you for the opportunity to provide comment today, and I'm happy to answer any questions.
Thank you, Mr. Pearson. Colleagues, any questions? All right, thank you, sir. Ms. Smith, has anybody else signed in to speak?
No one else has signed in.
Okay. Let me just share that I'm pleased to hear TCC support the notion of a future rulemaking. I do think that this is an important issue, and that we need to continue to work on it. Colleagues, any interest in doing anything different than the final action that we already took on this item?
No, I'm good with the final action.
I just want to say thank you for the comments, because it spoke directly to the one point that I most wanted to touch on this issue, and I think it really gave me a better opportunity to revisit it. And I think the numeric, I see we have another comment here.
Sir, did you want to speak to this item number 23, the water quality standards? Okay, we'll get to you in just a moment.
I do appreciate that. Now, I'll echo your sentiment, Chairman Neerman. I think where TCC recognizes the sentiment from industry to want to continue the dialogue here, and I think that the cost estimates for this purported change from industry reflect how serious they are taking what engineering might be required, what costs may be necessary for them to fully and adequately address it. And I appreciate and respect the process, and I want to see us continue to push this conversation forward to reaching a how and where and what limits are reasonable, and where our existing authority may give us existing ability to move further into this space. I look forward to that dialogue with Executive Director staff as well. So I sincerely appreciate the comments on the issue. It helps bring a little more attention to it here.
Thank you, Commissioner Janeka. There's no further action necessary on this item. Ms. Smith, I'll ask you to please call item 25.
Item 25 is our public comment session, and the commission will receive comments from the public on matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permitting matters or other contested cases, which are subject to the ex parte prohibition found in Texas Government Code Section 2001.161. In the interest of time, speakers will be limited to 3 minutes each, with a total time for public comment limited to 1 hour. Please note that the Commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response or the recitation of existing policy. First, we have Mr. Stan Mitchell.
Sir, this has been a long day already. I want to thank you for your patience with us, and thank you for being here to offer your comments.
Thank you. And good afternoon, Commissioners. Thank you for your service. I'm Stan Mitchell.
And sir, let me interrupt you. Do you see a light on, a green light on that microphone? I think it might have gotten turned off, and we're having a hard time hearing.
Oh.
There we go, much better.
Okay.
All right.
Once
Okay,
more.
from the top. Yes, sir.
Good afternoon, Commissioners. Thank you for your service. I'm Stan Mitchell, Harvard MBA, Bexar County resident, treasurer of the SAWS Accountability Act PAC, and as a consequence, respondent in a SLAP, acronym for Strategic Lawsuit Against Public Participation, initiated by SAWS and the City of San Antonio to stop our petitioning. We advocated for an audit of SAWS financial and environmental actions accompanying its Vista Ridge pipeline project. You have our petition and the 3-page, quote, extract from June 8th, 2021 confidential letter to law enforcement, close quote. Governor Abbott has acted against the SAWS city block before. A June 24, 2019 Express News article reported Governor Abbott's veto of HB 1806. That bill would have allowed SAWS to sell Edwards Aquifer water outside the boundaries of the Edwards Aquifer Authority. An August 22nd, 2022 Express News article by Elena Bruce reports, quote, Puente, SAWS manager, said he's been in contact with the city of New Braunfels in establishing its own center for aquifer storage and recovery, unquote. Governor Abbott blocked SAWS' drive for regional water hegemony in 2019, and here we go again. I share your concern for Texas water resources, and as a near-term emergency, the depletion of non-regenerating sand aquifers. Dr. Curtis Chubb, a Milam County resident, recently reviewed the matter with Texas legislature based on his 22-page, quote, petition for inquiry of Post Oak Savannah Groundwater District to the TCEQ, close quote, dated March 9th, 2022. You're aware of the Samsung plant in Taylor, Texas, frequently referenced in the Austin press since November 2021. Its demand for as much as 30.7% of the 55,000 acre-feet SAWS expects to receive from Vista Ridge LLC is startling. Further, water quality issues will increase as pollutants from Alcoa smelting operations near Samsung wellheads become more concentrated with a continued drop in aquifer levels. Please probe the ongoing cover-up by SAWS CEO Puente, ex officio SAWS board member Mayor Nierenberg, and other Vista Ridge adherents as they transition from unethical to criminal behavior at a point to be determined by law enforcement. I welcome your questions and comments. Your very helpful and capable staffer Megan Tock has my information. She is leaving with you a copy of this presentation script, which is complementary and supplemental to what you've already received. Thank you for your attention.
Thank you, Mr. Mitchell. Colleagues, any questions for Mr. Mitchell? Thank you, sir. Appreciate you being here today. Ms. Smith, who else is signed in to speak?
Liasa Turcott.
Okay. We're down to the tough ones who have
The nuts
stuck
and
it
bolts,
out.
eh?
Hey, thank you for your patience.
My name is Lisa Turcott. Who said my name a minute ago?
I'm sorry, it was probably mistyped into this registration form that I have. There's an extra A. My apologies.
Good job, Mr. Mitchell. I'm sorry? Good job. Well, thank you, ma'am. Good job. I'm impressed. My name is Lisa Turcott. I'm born and raised in Kingsville, Texas, but I live in Port Aransas, Texas, where my grandmother bought our house in 1957. We had to knock it down after Hurricane Harvey and rebuild. I moved full-time to Port Aransas in 2015, and what I've seen happen to our island is unbelievable. The young lady that was just up here talking about nurdles, Well, Jace Tunnel is one of our scientists at UTMSI there in Port Aransas and has an international nurdle patrol all over the world, finding bits of plastic and such in every kind of animal and human being that you can find. In our neck of the woods in San Patricio County, it's been allowed to, Exxon Sabic has built the largest plastic plant in the world, in our neighborhood. The Port Authority of Corpus Christi has plans to industrialize everything from the inner harbor in Corpus Christi, Texas, all the way down to the ship channel out into the Gulf of Mexico.
Excuse me, I have to remind you
Yes,
that
ma'am.
your comments can't involve
I'm not
pending
going to talk
permits or
anything
pending-
about the specific case, ma'am. I'm talking about the history that I know. And what I'm living as a Texas citizen, I'm addressing the TCEQ commissioners, correct?
And Ms. Turcotte, I guess I would,
What I'd like
I'll see
to
if my
say-
lawyer kicks me here, but you can identify projects that you're aware of. Let's just not get into
My point is-
arguing any of the specifics about any of them.
Don't want to argue.
Yeah.
I want to educate. I'm a 67-year-old woman. I'm probably older than most of y'all.
And we could all use some education, so go
And I
ahead,
live
ma'am.
there. Have you been to Port Aransas or the ship channel? Or have you seen the largest plastic plant in the world in Portland, Texas? Have you seen the flares that come from it? This doesn't have to have anything to do with your agenda, ma'am. This has to do with the state of Texas. I'm a citizen of Texas. I have grandchildren and hopefully grandchildren that will be able to take over our home in Port Aransas. It's a family home. I'm sure all of you have children and plan to have grandchildren someday. And the waterways there have to be protected. Right now, in the past 2 weeks, 15 to 20 loggerhead turtles have floated up onto the beach dead. I bring up the plastic plant because nurdles are in our world in plastic. I bring up Mr. Mitchell because he's talking about our water. And the water that we need in South Texas, because we're in a drought-stricken area, is very important. And I know y'all know that. But if it's dirty, or if the water that we get from desal plants goes to industry and not the citizens, what's happening? And the reason why I came to TCEQ today, I'm not an activist. I'm an educator at Texas A&M University, Kingsville, and an early childhood educator. But I've become an activist because I feel like TCEQ is supposed to represent us, the citizens of our great state. And our waters are very important, right? Right, Ms. Lindley? I mean, really. So that's why I came to speak today, not to speak toward any certain particular case, although I'm very passionate. The words I have written on my notes today are robust and spirited. 9 marine scientists from our area. Don't you think that Texas scientists should know about our waters better than somebody from Australia?
And Ms. Turcotte, I'll ask you
that's
to
it.
just
Thank
take a
you.
moment to wrap up. Okay,
I appreciate your time, and I hope that you rule in our favor to protect our environment.
thank you for your time, and thank you for being here. And Ms. Smith, who's next?
Kathy Fulton.
Ms. Fulton? Last but not least, thank you for your patience. Go ahead when you're ready, ma'am.
Yes, hello. My name is Kathy Fulton, and I live full-time in Port Aransas, Texas. I would also like to say I'm a member of Keep Her Wild. I'm also a member of Port Aransas Conservancy, and I was also the spokesperson for the Pro Se group. But I'm not going to talk about any of that, just clarifying who I am. I want you to know that after I have watched 2 years worth of these meetings in the last 2 years, I have read through all the marked agendas, and here's what I want to say. Today, right now, today, I think the third person that has actually made it to this podium is me to make an actual public comment during a public comment session. Why is that? Okay, let's think about this carefully. My comment here is not about all the crap I think is going on that shouldn't be going on. It is about the fact that it all starts here with this dais. And if you aren't supporting and promoting and encouraging public comment right here It filters down to everybody else that was here today. It filters down to the permit division, to the enforcement division, to everybody. Public comment has not been supported at all by TCEQ, and certainly not this dais. You put it at the very end of these agendas. You expect people to wait that long, and then they drop off. And in the last 2 years, just to be clear, right before today, 5 public comments were made. 5. That should be shaming you, because it is shameful. Now, you say that you are here to, or our theory anyway, is that you're here to protect our state water, our air, and our resources. That is what you are supposed to be, the guiding principle anyway. Yet, that means you're supposed to be representing the public first, not industry. But it's clear what's been going on for quite some time is it is industry. TCEQ really works great with industry, but sucks with the public. And I don't know how else. I'm a blunt person, and I just get it out there to all of you. If you want to actually make a difference, the way to make a difference is to not, 20 years, what was that deal about 20 years, and TCEQ is still trying to figure out salinity gradients? Come on, 20 years. It's not hard. Here's the deal. Saline, when you make a slight increase in saline, no matter what water it is, you're pretty sure guaranteed that you are going to kill some things doing it. If any of you have an aquarium, it's not rocket science, not hard to figure out. So I am trying now to get you take care of Texas. I kind of have to laugh at that poster over there. If you're going to take care of Texas, the first thing you need to do is be listening to the public first, not industry. Thank you.
Thank you, Ms. Fulton. Ms. Smith, has anybody else signed in to speak?
Not currently, thanks.
All right. I think I'm ready to have you call the next items.
Items 26 through 29 are for closed session, and the commission will meet in closed session in Building E, Room 211S at, do you want to go straight in? You want 5 minutes?
Let's go straight in.
Okay, right now, 12:51.
With that, the time is 12:51, and we are in recess.
The commission met in room 211S in Building E for closed session from 12:54 PM to 1:13 PM on items 27 and 28 as posted and noticed pursuant to Texas Government Code, Section 551.074. No action was taken. This agenda stands adjourned. The time is 1:15.